Good evening, ladies and gentlemen. This is the Municipality of Anchorage Board of Adjustment regular meeting, scheduled meeting of April 26, 2017. I'm Bernd Gutschow, Chair. Madam Clerk, would you please call the roll?
Dwayne Adams.
Here.
Bernd Gutschow.
Here.
Robert Stewart.
Here.
You have a quorum.
Thank you, Madam Clerk. We have in front of us an agenda for tonight, and presumably you have all looked at that. Are there any additions, deletions, changes that you wish to make to the agenda? Seeing none, this will be the order in which we proceed tonight. There are no minutes of a previous meeting. Why that is, I'm not quite sure, but what do I know? And there is no old business. The only new business on the agenda tonight is the hearing on BOA Appeal number 2016-1, Planning and Zoning Commission Resolution number 2016-029 for case 2016-0023, commonly referred to as the Nordstrom Rack at Sears Mall site plan review. First thing we have to find out is if there are any conflicts. Mr. Adams? None. Mr. Stewart?
I do not have any, but I want to put on the record that my daughter is not working in the planning area now. She's working directly for the Community Planning and Development Director in a position that does not handle anything related to these cases.
Okay. And I do not have a conflict either. Let us then consider the Appeal 2016-1. This is an appeal in a case that comes back to us. It has been before us before. In 2015, I believe it was. No. Anyway, we had occasion to rule on a prior decision of the Planning and Zoning Commission in this case. It was appealed to the Superior Court, and the Superior Court sent it back to the Planning and Zoning Commission. And I would like to discuss this appeal by going through the Superior Court decision, because I think it is useful in terms of shedding light on the appeal that we are here to consider tonight. Now, this Superior Court decision, and I'm looking at the record, pages 9 through 20. Came before the court upon the appeal of our decision not to require a public hearing in the case. And so the court was confronted with having to decide whether a public hearing was required. And we know, of course, no secret here, that the court decided that a public hearing had to be held. But I think it is useful for us to go through this decision and to see how the court came to that decision. When you look at the discussion on page, and when I'm referring to page numbers, I'm referring to the order itself, to the page numbers of the order. On page 5, starting on page 5, the court gives its reasoning why a public hearing is required in this case. I think it is interesting to look at how the court came to that conclusion. The court went through the various code provisions and came to the conclusion that basically there was as much argument first of all, the code provisions, if I can paraphrase it, the code provisions are ambiguous. And secondly, there could be as much argument for mandating a public hearing as there could be for not holding a public hearing as this board had done. Being in that way faced with a conundrum, the court looked at other ways to come to a conclusion on this, and it basically concluded that public policy favors holding a public hearing. And I think when you turn to pages 9 of the decision, the bottom paragraph, since neither the plain language of the statute nor the legislative history definitively resolves the issue, the court must discover the interpretation which best fits with concepts of justice and equity. And I think those are the three crucial words, justice and equity, that is required under the circumstances. Towards the bottom of that page 9, the court says, the only way to preserve a meaningful right to judicial review in such cases is to provide aggrieved parties with an opportunity to articulate their objections and build a record for appeal. And I think that is one of the crucial sentences here, because the court then comes to the decision that a right of appeal, and I'm looking at the bottom of page 10, any right of appeal is meaningless without an opportunity to build an evidentiary record at the level of the initial decision. Any appeal will place an appellant at an unfair disadvantage, as the applicant will likely highlight the proposal's economic benefits and minimize any potential drawbacks and complications. In other words, if you don't have a public hearing, any party aggrieved by the decision is really at a disadvantage. Because in looking at the decision that, in this case, the Planning and Zoning Commission prepares, signs, votes on, and presumably approves, an appellant can only guess at what should have been on the record and what wasn't on the record. And so what is really important is that a decision that is rendered by the court, by the lower body, Planning and Zoning Commission, that decision is based on having given an opportunity to all parties to provide input, so to speak, before the decision is made. And as we all know, in what led to the 2014 resolution of the Planning and Zoning Commission in this case, that was not the case. Only the owner of the property was given an opportunity to present the case. And because there was no public hearing, the opponents, mostly merchants in this case, merchants in the mall, really didn't have an opportunity to voice their positions and thereby provide some input to the Planning and Zoning Commission before it made its decision. And so when you look at it from that vantage point, what really is required, it seems to me, and I want to hear from you too as well, of course, is that before the Planning and Zoning Commission makes a decision, everybody has to be given an opportunity. Anybody who is affected by the case has to be given an opportunity to voice any objection or approval or whatever. And not only that, a decision that is made by the Planning and Zoning Commission needs to be in such a form that opponents have an opportunity to voice, to build a record, and to prepare in opposition to it and to appeal it on that basis. So when we look at this, and these are the guidelines from the Superior Court, and as you know, it was sent back to the Planning and Zoning Commission on that basis. Now, on the surface, the order from the Superior Court was simply to hold a hearing. And that's how, when we look at the transcript of what occurred, how in June of last year, the Planning and Zoning Commission, at the recommendation of the Planning Department, initially proceeded. They just took the position, hey, we have to hold a public hearing, let's hold a public hearing, and let's give everybody an opportunity to be heard. It was only towards the end of the evening that it occurred to the chairman, and after the presentation by Mr. Reeves, I think it was, that there's more to it than that, and that in fact what the Superior Court really required was, in essence, a new consideration of the entire record, of the entire case. And so that's what then led to the Planning and Zoning Commission directing the Planning Department to contact the City Attorney's Office and say, hey, what do we have to do here? And when they came back in July, it was in fact a mandate to reconsider the entire case. And so that's what was done in July. Now, and that's what then led to the resolution that is entitled, whatever it was entitled, 2016-029. So, when we look at that resolution, as we must, on appeal here, we really must determine initially whether that resolution satisfies the mandate of the Superior Court. And I would like us to focus on that aspect for a while, if we can. Okay. So, having given this long speech here, I first would like to hear from the two of you what your thoughts are initially as to how we should attack this appeal. Because as you can tell from my presentation, I would like to attack it on the basis of, does it comply with the court's order of December 2, 2015? Any thoughts? Mr. Stewart.
Well, I think one of the things that I'm looking at from the resolution is that to me, there is a strong implication that any hearing would be fair and impartial. So that's what I tried to look at as I went through the record. And, you know, there's some municipal code references that talk about it needs to be that both in fact and in appearance. And some of the things that I looked at in there seemed to indicate that they had made their mind up beforehand and that they just were kind of going through the motions in order to fulfill this requirement of having a hearing. And it seems to me like in a couple of places that they may have applied the wrong test in determining some of their discussion in what was constituted during the last hearing. I think it was on the 14th. Some of the things that I saw were it looked like when they were talking about modifications, and this might be going into the weeds a little bit too much, but they were looking at modifications that increased conformity, but it seemed like they were making the decision based on the current status of the construction, not as where the LRE was in comparison to the May 8, 2001 code. So it looked like they were applying that in a manner that showed bias on their part, and there were several comments made about that. So I tried to focus on the hearing as it was implied to be conducted fairly and unbiased. And if you look at Anchorage Municipal Code 21.55.130, it directs the planning and zoning to process the application in the same manner as a proposal for a new facility. But when you get into the hearing part, if you look at the oath in 1.35.010, boards and commissions are sworn to support the state constitution and the Anchorage Charter. And then if you look at Anchorage Municipal Code 3.60.065 in the ex parte, it says commission shall be impartial in all matters, both in fact and appearance. And then I looked at some case law involved in this, and I'm not sure. I think it's still current. I think it's good case law. But it was State of Alaska versus Lundgren Pacific Construction, 603 Pacific 2nd, 889. It's a 1979 case, and they discussed administrative due process. And then they referred to, it's either Keener or Kiner, K-E-I-N-E-R versus City of Anchorage. And that was a 378 Pacific 2nd, 406, and it's a 1963 Alaska case. In that case, the city council acted as the board of adjustment, and what the process that they looked at was due process requirements. Was the hearing conducted consistent with the essentials of a fair trial? And some of the other tests they applied was the board was not impartial, and there was no substantial failure to follow or observe applicable laws and rules of procedure. And in that case, the impartiality of the decision is an essential element of due process. So what I was looking at was the impartiality, whether or not it met the requirements of an actual hearing. And I have some questions whether or not the intent of that public hearing was actually met.
Yeah.
I guess I had just a couple concerns as I read as they were summing up certain language that I found troubling. The test is whether it complies with conditions it's outlined in the bridge document, basically. And it's pretty straightforward, actually, what it has, and what I would have looked for in having sat on the planning commission is to look and respond directly to those. But the sort of thing that always troubles me is language like, if you look at other malls, other pad sites, people get out in the traffic all the time. And I believe that petition is as good as anyone can do. Well, that's not the test. And I found that language kind of troubling, that a lot of this kind of speaks to what Bob started with. That's a simple matter that it begs the question, where they focused on, okay, we've got an approved proposal here. Now, what do we got to do to make it work? And that's not the test. That's not what was referred back. It was not referred to them as, well, what you got to do to make it better after you listen to the public. It was new evidence, and based on that evidence, what will your finding be? And that's the thing I found troubling. That one stood out to me, but there were several others that, well, it's probably as good as we can do. And that sort of language that's not appropriate. It needs to be evidentiary in their findings. I'm not sure that the findings represented to the degree necessary, specifics with respect to why we approved this. It did tend to place a little doubt as to when they entered whether this truly represented consideration of all the facts of the case as a whole.
Well, while you were talking about that, it occurred to me that there is a regulation that requires boards such as P&Z to prepare their decisions in a particular manner. And what I'm looking at is AMCR 2110-304, which says every decision made by the Commission shall be based on and include findings of fact and conclusions. Every finding of fact shall be supported in the record of the proceedings, plural. The findings shall be sufficient to provide a reasonable basis for understanding the reasons for the decision. In considering and applying any applicable approval criteria, the Commission shall make specific findings as to why the criteria have or have not been met. And I think that's what you are just saying. Because when we look at the resolution, and I'm trying to find it. Oh, I have it right here. When you look at that resolution that presumably was adopted on August 8, 2016, and that, by the way, is another issue here. When you look at that resolution and you look at the portion that is entitled Findings of Fact, well, lo and behold, it is virtually identical to the resolution that was passed in 2014. Because if you look at that, and remember, this board tinkered with the resolution and supplemented it. So when you leave out our supplementation of that 2014 resolution, well, lo and behold, it is virtually identical. It is as though there was no hearing held at all following 2014. The only difference between those two resolutions that I could discern was that the 2016 resolution added two conditions, and they had to do with a pedestrian sidewalk and signage along the north side of the Nordstrom rack, and to construct the approved sidewalk and install the approved signage along the north side of Nordstrom's rack. And this was apparently added because the petitioner himself offered to do this. This was not as a result of the hearing. This was strictly in response to what the petitioner, maybe realizing that there was a deficiency here, offered to do. So the sidewalk was issued and the signage was added as additional conditions in the 2016 resolution. But aside from that, it is virtually, and in substance, it is identical to the earlier one. And I must tell you, considering the evidence that was presented at the public hearing, that is most surprising, because there are all kinds of things that were brought out at the public hearing that, to my mind, would have raised all kinds of red flags in terms of what had been approved before. So it seems to me that, plus when you read the findings, they are, I'm not sure what they mean. Look at finding number 3, for example. Finding number 3 says, northern design elements should be implemented where possible, semicolon. The covered walkway between entrances is shortened. What does that mean? Does that mean that it brings the project towards conformity? And we can talk about this for a long time later on. Or what does it mean? What does that sentence mean? Why is that added? Does it mean that more northern construction elements need to be added? Or is it sufficient the way it has been done? All it says is the covered walkway between entrances is important. Well, means nothing to me. And I'm sure it doesn't mean anything to anybody outside the Planning and Zoning Commission looking at this. And anybody doing that would come to the same conclusion. It's incomprehensible. Next one. The loading dock addition, and I'm looking at finding of fact number 4. The loading dock addition, while necessary for the use, does not promote the balance of the additional building that is without a prominent front side and divides the pedestrian access. What does that mean? Now we know that findings of fact have to relate to evidence that has been presented. How does this relate to evidence that has been presented? And it seems to me, when you go through the findings of fact that are listed as number 1 through 5, they are, in the light of the court's decision and court order, they are totally insufficient because they do not give an aggrieved party an opportunity to discern how the decision that they arrived at, which was to approve the amended site plan, how it was arrived at. What are the facts that caused the Planning and Zoning Commission to come to the decision to approve the amended site plan? Can't tell. Now, there is, and while I'm talking about this, there is a formal defect, by the way. I don't know if you have noticed this. The resolution says on page, it's page 8 of 296. It says, passed and approved by the Anchorage Planning and Zoning Commission this 11th day of July 2016. Adopted by the Municipal Planning and Zoning Commission this 8th day of August. Well, what was passed and approved on July 11, when we read the transcript, was something entirely different. There was a motion made and the motion passed. So this resolution was not passed on July 11. Instead, there was a motion made that passed. The reference to adopted by the Municipal Planning and Zoning Commission this 8th day of August, I don't have the foggiest idea where that comes from. There's nothing in the record that is before us, and I have searched high and low. There is nothing in the record that shows that this proposed resolution was approved by the Planning and Zoning Commission on that day. I'm not even sure they met on that day. We don't know. There are no minutes here. There's nothing to support it. So the question is, what is this based on? And particularly when you look at it and say, this is virtually identical to what was done in 2014. What springs to your mind, to the innocent mind of an observer, is that this was simply prepared by the planning department and was stuck under the nose of the chairman, and he signed it.
If I may,
Yes.
I know that the way that they often work is that this resolution or a motion, which they're calling the approval, took place on the 11th day. That's when the public hearing was, that's when the motion was made, and this resolution wasn't approved, but a motion was approved. So that's
Yes.
right.
As
So
I said,
that their standard way of doing business is then that staff drafts a resolution. That resolution is presented to add on the consent agenda at the following meeting, which I presume to be 8th August. And that at that point, right or wrongly, if it's not pulled, then it's considered passed and adopted. So that's not an unusual way for them to do business. Now, whether that's right or wrong is a whole different discussion, perhaps. But that is a typical way that they do business.
Okay. Well, then perhaps what is missing simply is a set of minutes relating
It shows-
to August the 8th.
Correct.
That it was on the consent agenda. It's entirely possible, but
Yes,
we
it
don't
is.
know.
There's no evidence, no.
We just don't know. So I think that, I must tell you, I view that as a problem. So the other thing that struck me was, and I need to call on you, Mr. Adams, on the basis of your experience, when you look at the transcript of what occurred on July 11, was that a motion was made, and then there was a little bit of discussion, virtually nothing relating to findings of fact. The motion was called, it was voted on, it was approved, and then the chairman, apparently recognizing that there were findings of fact missing, called on members to supply findings of fact. Was it the usual, or is that a usual method of proceeding? That shouldn't it be the other way around? Aren't we putting the cart before the horse? There should be findings of fact before you vote on this thing?
Yes, there certainly should be. And they should have, there should have been discussion, but it's not unusual for them to make a motion. And in fact, it is actually often the case that a motion will simply be made to get it onto the table, and then it is discussed
Yes.
as a body of the whole. Well, not as a body of the whole, but as while sitting. And then that the maker of the motion will vote against it, but advance the motion just to get it on the table for discussion first. That's their typical way of doing business. So it's not unusual that they would make a motion, but they certainly wouldn't vote on it beforehand, of course. But that is a standard way of doing business.
Yeah, and having served on another land use planning board myself, I'm well familiar with that. But at least you need to refer to the findings before you vote on the motion, it seems to me, because
Yes,
presumably
absolutely.
the decision is based on the findings. And here, you don't have that. Because when you read the transcript, and I'm not going to go through this, we don't need to do that, but you are left with the impression that at the July 11 hearing, the motion was made, and as you said before, they had pretty much made up, the members of P&Z had pretty much made up their minds beforehand, and they were simply going through the motions of approving the what was then later on turned into a resolution. There was nothing until the vote was taken that I can find that related the requirements of the code, and I'm specifically talking about 5130, I'm sorry, to the facts as they have been presented. And it seems to me that that is a significant deficiency.
One thing that you can see the struggle on page 134 of the record is that motion carries, and then Chair Robinson says, "Are there additional findings?" Now that's unusual. I've not seen a request for additional findings after the vote takes place.
Okay, that's precisely what I was referring
That's
to.
very different.
It's putting the cart before the horse, is it not?
Yes, yes, I would agree.
Mr. Stewart?
No,
You're a lawyer,
that's-
what do you think about this?
That's the basis for my observation that their mind was already made up, and it was not a fair and impartial hearing. It was it was not even a work of art. They just went through the process thinking that a hearing is all they needed to do because they'd already made the decision.
Okay. What do you make out of the fact? I don't want to overstate this, but I've mentioned before that the two resolutions, the earlier one, the 2014 resolution, and the 2016 resolution, are substantially identical. Am I overstating this? Because what I'm getting at is, if I had been on the Planning and Zoning Commission in 2016, and I had heard this litany of complaints, I would have made sure that there are some findings of fact that either support my decision to approve this in spite of all of the evidence, or I would have voted against it, and I would have said, here's why I'm voting against it. Here's all the testimony that we've heard. Here are the documents. Remember, there were pictures taken and, all these things. Am I off base in saying that those things should have been added to the later resolution?
I don't think that there's any nexus between those two. I think there's no findings to support it. I think what they did is that they made a motion to accept what planning and zoning or planning department had presented to them, and accept what was in that advice from the planning department. That seems to be what they based their resolution on.
And that's not
Mr. Adams?
ordinary, that they would not simply go to what staff provided them. Now, I think a lot of that was based on the previous motion, which carried the one that was appealed, and the first one that was appealed, I should
Yes,
say.
yes.
And, my reading of this, if we step back at 10,000 feet, is they have a case that they feel they passed. They worked at it, and so they were directed out of a public hearing. That public hearing, out of the testimony, they culled all the things they could that they thought were important. And I think I'm moving a little bit beyond where we are right now, but in essence, 2/3 of that was removed from the table. And so what they were left with was lighting and an access issue. And that's what they dealt with, and virtually everything you see here in their findings of fact speaks to that, and it doesn't really speak to the rest of this, all the other stuff that are called findings of fact, whether you agree that they are or not, which I agree are pretty weak. But they dealt with those things that they could deal with that did come up in the public hearing, and in essence, a broader discussion and findings of fact on other things just disappeared because those issues were deemed moot by staff direction. So that's removing, often another discussion, I think, here. But, I think that's, the way I read it, that's what the chair was trying to get to is, well, he asked, well, anybody else? I'm trying to build something here.
And it didn't come.
Yeah, I'm going to ask people to speak to the important aspects of that if you support it, because I want to know what's negotiable and not negotiable. I mean, traffic engineers. So he's really focusing on an access issue, and that's what it distilled to, was that singular issue. And so any building of findings of facts beyond that, just kind of, I think they felt that they dealt with it. The public didn't speak to it, so they didn't either.
Okay. So, I'm sorry, Madam Clerk?
Mr. Chair, I'd like to bring up a procedural matter. Assembly Council Dean Gates just joined you by telephone. That's why your telephone rang, and I just wanted to make sure that you understood that Mr. Gates is listening on the phone.
Okay, thank you so much for telling us. I appreciate it. Now, we know that there are two really crucial code sections that are involved in this entire matter. The first one is .55.138. That is the one that is the framework for considering this entire matter, and it incorporates .50.320. Do you find, without going into the details, do you find anything in the resolution that tells you that P&Z has addressed, first of all, the main considerations under .55.130 and also under .5320? Do you find anything in that resolution that we are here deciding whether it passes muster or not that refers to those sections or the standards and considerations that are in those ordinances? Mr. Stewart?
I didn't find any of that in there, but I think what Dwayne referred to, those issues that were brought up during this hearing that they could address, that's what they addressed. But I think what they were doing, and there's discussion in the transcript where they talked about, well, we could accept what we've already done and go from there. So it doesn't, I think what it showed to me is that they did not feel like they had to go through this, where in my perspective, I would look at it and say, this is complicated. We were told to go over a new one or have a hearing. I would have gone through the whole thing and looked initially as though we had never had the case in front of us
Well, in
to
fact,
set the record up.
In fact, isn't that what the Code of Procedure requires? Remember, I read to you this section that relates to findings of fact. Every decision made by the commission shall be based on and include findings of fact and conclusions. Every finding shall be supported in the record of the proceeding. The findings shall be sufficient to provide a reasonable basis for understanding the reasons for the decision. Doesn't that mean you have to refer to the two code provisions that are really crucial in disposing of this matter, i.e. 55.130A and 50.320? Shouldn't the evidence that was produced or the basis for their decision, shouldn't that have tied into those two code provisions? Isn't that what basic fairness requires that the Superior Court talked about in its order?
I think they offer one simple broad brush, and that is the Commission makes the following findings of fact. It complies with the standards in 55.130 and 53.20. So that,
Yeah, but what
that
does
was
that mean?
that was a rather broad brush.
That doesn't explain.
No.
It
how they
doesn't
arrived
explain a
at
thing,
this.
does it?
Well,
It doesn't give you the nexus.
No. Well-crafted resolution should have addressed each of the aspects and discussed the conformity with that. Especially since what's key, the nut of this whole thing is this question the appellant calls it backsliding, whether there was backsliding. So the issue, and one of the key issues is, did they conform or not? Does it conform or not? Does it conform to each one of these? And there should have been a discussion of that, because that was part of the public testimony. There was a lot of public testimony about their backsliding. They're falling away from conformance. And there was a minor amount of discussion. John Spring talked about that in his discussion. But it was a pretty broad brush that was applied, and each of those criteria that's in there should have been discussed, whether they met and conformed with that, and discuss the issue of, did they backslide, whatever term you want to use. Did they move towards or away from conformity in each one of those, because that is critical to the whole issue.
Okay. There is another aspect that troubles me, and that is that the department may have accidentally misled them, I'm not sure. But when you look at the department memorandum, and it's at the beginning of, where is it? Let me come up with
29
it
of
here.
the
Oh, it starts at page 29 of the record. When you go through this, it starts out, the commission was, let me find this. It was really striking that basically the department took the view 55.130. Oh, here, I have it. It's on page 29. The changes to the Sears Mall are reviewed under AMC 2155.130, which states that, quote, the commission shall apply the standards set out in 2153.20 in a manner proportionate to the extent of the expansion, reconstruction, renovation, or remodeling proposed, period, unquote. The cost of compliance with those standards shall not exceed 10% of the cost of reconstruction. Now, that's not at all what 2155.130 states. That's only a small portion of what that section states. That section is the underpinning for the entire proceeding, and it is fairly long. And as you have read in, there are 6 or 7 sentences that are in point 130, and they all have a particular meaning. And in fact, when you look at this in our trustee code here, you come to the conclusion, as I did, that is another section that was very poorly drafted. And so I'm hopeful that this didn't come back into the new code. I haven't checked it, I must tell you. But when you look at that section, it goes on for 3/4 of a page, and there's a lot stuffed in there. In fact, if I had been drafting this, and remember, I'm just a little old country lawyer, I would have turned this into 7 different separate sections, because each sentence has a particular meaning that is important. And these sentences are not necessarily connected. And as you determine from the planning department's view, all those 7 sentences can be reduced to 2. Well, that doesn't do justice at all, and it gives the wrong direction to the Planning and Zoning Commission, in my view, because I'm not sure that they ever even read that long section. They were not urged by the department to do that. I didn't see any particular discussion of it, and so I'm not sure that they were aware of all the requirements that that section imposed on them. So I must tell you, I find this resolution woefully deficient. And we have discussed it, you have mentioned it, you have voiced your views on this too. Is there any further discussion before we try to formulate this into some action?
Well, I guess, what's real troubling is it directs them to adhere to these, apply the standards, and then adds this statement. And as soon as that statement's added, then that's where the attention goes to, that's the focus of the statement, is that's a conclusive.
It's a conclusory statement.
Concluding statement.
Yeah.
And so, okay, so 10%. So, adhering to these other pages, 7 pages I think we have here, then becomes subsidiary to the concluding statement, I think, just by its simple focus. So it is a poorly crafted memo, I think, but that does not remove the Planning and Zoning Commission from having to meet its requirements. And so the question remains, do they meet the requirements regardless of what the staff package said? Now, whether they're erroneous direction is a whole different matter that we'll talk about, but that's quite poor action.
Okay. Mr. Stewart, anything that you wish to add at this point?
You're talking only in terms of the resolution right now, right?
Yes.
No.
Okay. The resolution talks about, I think it does, talks about the 10%. Let me find this here very quickly. Why can't I put my finger on it right now? Here's the resolution. Okay.
No, the resolution does not, the 2016 resolution, I don't believe addresses any 10%.
It does not address the 10%, but there was discussion at the hearing. And they were under the impression, they meaning the Planning and Zoning Commission, was under the impression that the 10% rule was the maximum that could be or was required to be spent by the applicant towards bringing the project closer to conformance. And it was based strictly on the cost of work related to exterior stuff, not interior stuff. You will recall that argument. Well, where this originated from, apparently, was from a memorandum that the planning director at the time, Mr. Weaver, prepared, because when you look at Mr. Odell's memo to the Planning and Zoning Commission, starting at page 29 of the record, when you look at page 31, it says, as noted in the attached department memo from 2009, the goal of the department is to use this 10% dollar figure to work on bringing the expansion of the new structure and the existing structure towards compliance with the architectural standards, while also trying to bring improvements to the site. And then you look at Mr. Weaver's memorandum,
Page 41.
page 30.
41.
Page 41.
Right.
Page 41. He indeed says that interior remodeling, I'm looking at the middle of the second paragraph, interior remodeling, renovation, or repair to interior portions of large retail establishments is clearly exempt. This would be true if the remodeling is within the same existing footprint of the existing structure, or if an addition to the building is planned, or if a new structure is being added to the site. So he has his own interpretation of this troubling sentence in 2155-130 that refers to the 10%. I'm not sure that he's correct, first of all. Secondly, this apparently is viewed as gospel by the planning department, and it appears that it was accepted as such by the Planning and Zoning Commission. So we need to take a look at that. But it seems to me that this is some kind of an interpretation that was never sanctioned by anybody other than Mr. Weaver and simply has been passed along. And I think that's problematic in view of the municipal requirements for passing the regulations. So I'm simply throwing this out. It is something that we need to talk about later on. Anything else that you have to observe or that you're observing regarding the 2016 resolution by the Planning and Zoning Commission? Anything else at all? All right. I have nothing further. It seems to me we have discussed the resolution at length, and the question is whether that complies with the court order, first of all, and secondly, whether the resolution complies with the code mandates, specifically point 55-130A and 50.320. And so, just to get this matter on the table and give some direction to our proceedings here tonight, I would entertain a motion that relates to that, to either find the resolution 2016-029 either complies or is deficient. Mr. Adams.
Move that the Board of Adjustment find that 2 points. First point being that indeed the Planning and Zoning Commission did hold a public hearing as required by Superior Court, but that in doing so we find that their findings are sufficient to address the requirements to illustrate that the proposed project complies with AMC 2155-130 and 2153-20.
Okay. And Mr. Stewart, will you be seconding that motion?
Question first.
Oh, I'm sorry.
I'm not sure that I heard the second clause of that.
The second clause is that we find that the Planning and Zoning Commission did not provide findings of fact that illustrate compliance with the proposed project with the requirements of AMC 2155-130 and AMC 2150-320.
I hope you're taking notes.
Well, I think
Through
the
the-
clerk takes all the action motions down, so I wasn't sure that I heard it in the positive or the negative. So I'm not, it's taped, and do I have that right, that you'll be transcribing the actual words of the motion?
Yeah, but
Yes.
not tonight, that's the problem. So we need to have something, because we need to address this tomorrow.
I think he phrased it in the negative.
I think he
Did
phrased
not
it in the
provide
negative.
findings.
Yes.
Mr. Chair, my request would be that it was actually two motions in one, and for clarity of the record that I'm creating for you.
Yes.
If you could make it two motions, that would be more helpful as well.
Okay.
Is that, do you?
I
do you
understand what you're
I'm
saying.
asking?
That's
And
fine, yeah.
Wayne, would you address that issue, please?
Move that the Board of Adjustment find that the Planning and Zoning Commission conducted a public hearing as required by the Superior Court in their
Order for remand.
order of remand. Thank you.
All right. Is that clear?
That is very clear.
Terrific.
I'll second it
Mr.
for
Stewart,
discussion.
you are seconding that for discussion, Mr. Adams?
There was a lot of discussion in the Superior Court order, but fundamental to that was the simple matter of conducting a public hearing in accordance with the requirements of the municipal code. It was adequately advertised, and the public had an adequate opportunity. In fact, it was actually reopened to provide additional testimony, which did take place. And so, based on the evidence that's provided, it appears that they complied with that part of that court order.
Mr. Stewart?
So I have some difficulty with the definition of a public hearing as it's used here, because if it's a public hearing, it should be fair and impartial. It should meet all the requirements of due process. And I don't think this public hearing did that. At least that's the way it appears to me so far. So are we, if we approve this motion, we're saying that they met all the requirements of a public hearing, or did they just go through the motion? We have a question over here, Brent.
Okay.
Baron.
Yes.
And Dwayne also. Do you want to speak first?
Well, I guess I have a question is what is the definition of a public hearing? Is the action of the body, because they close the public hearing before they take action or even discuss it internally. So in my interpretation of a public hearing, it is that aspect of the hearing of the public testimony in a public forum, that is a public hearing, that is gavel closed, that took place. Now, whether the procedures were correct afterwards is the second motion.
Okay. So really, what you're saying is you're viewing the public hearing requirement as something different from the way that Mr. Stewart is
Different than I'm
looking at
looking
it. Okay, but does it make sense to you? What we are trying to do at this point, I think, is to see if, at least on the surface, the Planning and Zoning Commission has complied with the order of the Superior Court.
Could I?
Yes.
Make a comment. The way that Mr. Adams combined two things, I think that one thing that could help reconcile what I'm hearing each of you saying is to go to the record at page 17, which is page 9 of the order from the court. And what the court says is that, moreover, the only way to preserve a meaningful right to judicial review is to provide aggrieved parties with and then I'm going to insert, one, an opportunity to articulate their objections. So we call that also an opportunity to be heard. And two, to build a record on appeal. So maybe if your motion was rephrased to say that in compliance with the order, P&Z made sure that the public had an opportunity to be heard, then we're not going to get
The definition doesn't get.
yeah. Does
I
that
think
make any sense?
I think that's a good fix because
Yeah.
it tells they were given the opportunity to be heard and that they were given the opportunity to build a record on appeal or for appeal. So that would meet those two criteria, and that would suffice. That would take care of my objection.
Okay.
Okay. So, may I rephrase that?
Yes,
Because I don't think
please.
there's a second, is there?
Yes,
For
there was.
discussion, we did.
There was.
We had to
Okay,
amend it.
so, with approval of the second, I'll remake my motion, if I may.
Go ahead.
And, excuse me, that the Board of Adjustment finds that the Planning and Zoning Commission provided a right for the agreed parties to provide input to this process and articulate their objections for the purposes of building a record for appeal.
Okay. Mr. Stewart, does that comport with what you want to second?
I would add one other thing.
All right, and what is
Just
that?
an amendment. In a forum in a public hearing forum. So we get public hearing in it.
Well,
Are we back into the track?
we are back into the trap.
Wait a minute, you used public hearing already in the beginning, right?
No, not this
What?
time.
No,
No.
Maybe you could
public-
rephrase it so I can write it down.
why don't you, Mr. Stewart, why don't you try to
I'm not
rephrase
rephrase
the
it. I didn't
entire...
mean rephrase, I meant you would repeat it. I misspoke. 'Cause that's so I could
Repeat
get
the
to-
motion as you understand it.
The P&Z provided the aggrieved parties with an opportunity to articulate their objections and provide build a record on appeal or for appeal.
I will accept that as a friendly amendment.
Okay.
Or however we want to phrase that, but I accept that.
Wait a minute, our esteemed counsel here is writing, and this is crucial that she gets this down.
Okay, so I have some of the words here. The P&Z provided the
Aggrieved parties
aggrieved parties with
the opportunity to, actually, it would be rephrasing the court decision on the public policy.
Wait a minute. Provided the aggrieved parties with opportunity
To articulate objections and build a record.
to articulate objections and build a record for appeal.
Now, do we,
Page
on
9.
page 9.
do we need to add through a public hearing format?
Yes.
Are you waiting on me?
No, you're waiting on me with my slow writing here, because I'm trying to also write the motion down.
Yeah, just while we're paused here for a second, I think what I find interesting is on the top of 18, that the statement is, the court concludes that the commission must hold a public hearing on all proposals to modify large retail establishments. That one is an eye-opener to me, without modification as to what that means.
But we don't need to worry about that.
It doesn't matter
It's-
on this, but
no.
it certainly opened my eyes.
Okay, so the motion is, and I need to call on both Barbara and Julia to correct me if I'm wrong. The motion is that P&Z provided the aggrieved parties with an opportunity to articulate their objections and build a record for appeal through a public hearing.
Okay, for some reason I'm in process at the end of that, but through a public hearing.
Mr. Chair, could you read the last through a public hearing? Is that the way the sentence ends?
Yes.
Okay. And then I would like to add, Mr. Chair, that the beginning of the motion started, the Board of Adjustment finds the P&Z.
Thank you.
Oh.
And just by way of explanation, the reason that we are trying to get these motions down is because the normal procedure is that we await the transcript by the clerk's office, and that usually takes a few days, and we do not have the luxury of waiting in this particular case because our esteemed counsel is leaving Friday evening, and so if we don't put this whole thing to bed by Friday evening, we are in real trouble. And I would like to avoid that if I can. So that's why I want to be sure that all the motions that we're making, that they are clear, and not just on the record, but also clear to those of us who have to take notes here, so that they can be reproduced here in the next day or so. All right. Madam Clerk.
Mr. Chair, Mr. Stewart made this motion, and that's all the farther we've got. We've got the
Well-
motion.
Well, actually,
It was an
it was an amendment. It was by way of amendment. The original motion was made by Mr. Adams and then amended by Mr. Stewart with the consent of Mr. Adams. That's how procedurally it worked.
Okay.
Okay? Does that make sense? Am I correct?
Right, so then you're going to vote on it.
All right. Anything further to be said about the motion?
Okay, I just want to clarify for the record, this I interpret as meeting those two criteria in a public format type hearing, not
Yes.
going to the basis of whether it was fair and impartial or anything like that.
No, that
Okay.
is correct, because that's the second portion
Okay.
of the motion, and we have bifurcated it. Okay? All right. Mr. Adams, anything further you wish to add at this point? All right. So this is as far as I'm concerned, this is the most non-controversial aspect of the entire thing this evening. So, Madam Clerk, would you call the roll on the vote, please?
Yes. Mr. Chair, Mr. Guicho?
Yes.
Mr. Stewart?
Yes.
Mr. Adams?
Yes.
Thank you. Approved 3-0. All right.
You phrased that though.
Now then, Mr. Adams, you had a second portion of the motion, and this is a standalone second motion.
See if I can remember it. Bob liked it a lot, so now I don't remember what it said. The Board of Adjustment finds that at the conclusion of the public hearing and upon deliberation that, well, let me pause here. We're looking for a positive motion. So it's
Yes.
a motion that so that would suggest that I say we find that they provided findings of fact. Yes.
I interpret this rule to be, if you state it the way that if you were voting, your vote would be affirmative. Otherwise, we get a double negative. If you say that they did something that, because I understood your motion to be, and that's why I asked you about repeating it before. I couldn't tell before you were saying that it was sufficient or insufficient. But if you are thinking that it's insufficient, then your motions should say that the board move that the Board of Adjustment finds that planning and zoning's resolution following public hearing was insufficient, blah, blah, blah. Then the response to that is a vote yes. If you say something and then you vote no, it's not that, then you're going to be here all night voting on things that are no. It's like, there's no alligators.
Okay.
See, that's my belief as well, because wherever we go, it provides specific direction to wherever this goes, whether it's whatever we do.
And it is true that in the past I have favored positive motions. It is true. But I think in this case, I think it would be better if you phrase it in the manner that you feel about the subject matter.
Okay, Mr. Chair, move that the Board of Adjustment find that at the conclusion of the public hearing, and I'll speak slowly, and after deliberations, that the Planning and Zoning Commission did not provide findings of fact sufficient to document their decisions and reflect compliance with 2155-130
A. There's a capital A there for some reason.
AMC 2155-130
A.
AMC.
No.
A.
It's 130A.
Oh, is it?
There's no B, but it says A for some reason.
I want to be absolutely right, so I want that A in there. And AMC 2155-320.
Okay. All right.
So it helps me if the
Well,
clerk,
we want-
even if they,
50.
we're not going to see it,
Yeah.
can read back what she has, but what I
Barbara,
have.
what do you have?
20 minutes.
My pleasure. The clerk has, the Board of Adjustment finds at the conclusion of the public hearing and after deliberation, the Planning and Zoning Commission did not provide findings of fact sufficient to document their decisions, and something that started with REF and reference, I believe, compliance with 21 dot, is it 50 or 55?
55.
Okay, 21.55.130A and AMC 2155.
No, 50.
Oops.
50. The second one is 2150-320.
Okay, so let me try I'm just going to start compliance with at the end of the sentence.
Okay.
Compliance with AMC 2155.130A and AMC 21.50.320.
My only question was the project's conformance. Did we say that?
You did
Because,
not.
okay, it needs to say document the project's conformance.
Try again.
So start from the top.
Start from the top. Board of Adjustment finds that at the conclusion of the public hearing and after deliberations, the Planning and Zoning Commission did not provide findings of fact or conclusions of law in compliance with 130A and 320.
I think it should say that document the project's conformance with the requirements. Does that make sense?
Did not provide findings of fact or conclusions of law
To document the projects. We could say proposed projects, compliance.
document the proposed projects compliance with.
Yes.
Okay.
Okay, so, Mr. Chair, I have
Yes.
a couple of different, a couple of added words and a couple of missing words, so I just want to make sure that I've got them all.
Okay,
Okay.
all right.
One of the words that you dropped that time was sufficient. Findings of fact or conclusions of law sufficient to document.
Sufficient to document, okay. Good.
And then this time you dropped their decisions in reference. And I think it probably makes more sense, so I'll read it without those.
Please
words.
do.
Okay. The Board of Adjustment finds at the conclusion of the public hearing and after deliberation, the Planning and Zoning Commission did not provide findings of fact or conclusions of law sufficient to document the proposed project's compliance with AMC 21.55.130A and AMC 2150.320.
Okay. Mr. Adams, does that reflect your motion as you wish it to be?
Yes, it does.
All right, and I will second that. Would you address the motion, please?
Through the chair, we spent quite a bit of time in the earlier portion of this evening discussing the several issues. One of those being that based on face value, if there is a possibility that someone could conclude that members of the commission may have accepted the project as approved, and with the intent that perhaps just a bit of tinkering was all that was necessary. There's also a question whether they complied with many of the requirements and only dealt with a very narrow portion of the project. All of that, as well as some concerns that Robert brought up, beg the question of whether there was fairness and a record built that, as the court order requires, that could be a basis of appeal if necessary. And with respect to that, that's what the findings of fact do, and they were deficient in this case.
Okay. I have previously spoken about my view of the insufficiency of the resolution, and I will simply incorporate those comments for purposes of us voting on the motion. Mr. Stewart, anything you wish to add?
It's just that, for the record, I agree that the findings are not sufficient to provide that nexus between findings in the decision and between the conclusions that were drawn.
Okay.
So I intend on voting to support it.
Ms. Tucker.
I have one minor technicality for the chair's consideration. When the motion was repeated by the chair, well, let me back up. The standard in 2110-304 is that every decision made by the commission shall be based on and include findings of fact and conclusions. And the words of law are not necessarily, conclusions can be of various things. I know that as attorneys we're used to throwing in every time we hear conclusions to be findings of fact and conclusions of law, but the code doesn't say that. And so I would just...
So you would request that we drop that last portion after conclusion? Okay, all right. Mr. Adams, any problem with that?
Sounds good.
Okay, it's acceptable to me.
Certainly not
If you feel that that's a better way to proceed, I think that's how we ought to do it. Okay, and the record should reflect that the words "of law" have been dropped from the motion.
It will do so.
All right. Are we ready to vote on the motion? If so, Madam Clerk?
Maracucho?
Yes.
Mr. Stewart?
Yes.
Mr. Adams?
Yes.
And the motion passes 3-0. 3-0. So having concluded now that what the Planning and Zoning Commission did was insufficient, the question is, where do we go from here? When you look at the powers of the Board of Adjustment, you come to the conclusion that pursuant to 2130.095, we can either affirm or reverse the decision of the Planning and Zoning Commission in whole or in part, or we can remand the matter back to the Planning and Zoning Commission. And what we have done in the past is that we have also made separate determinations, well, that we can supplement motion resolutions, and you will recall that we have done this with a 2014 resolution, that in fact we supplemented that rather than send it back to the Planning and Zoning Commission, and it stood, and because we have that power. And so my question really is, what are the druthers of the other members here? Do we remand this, or do we substitute our own decision for the Planning and Zoning Commission decision? Do we supplement the resolution of 2016? Where should we go from here? That's really the next thing that we need to decide. And by way of introduction, let me just tell you that I'm not terribly keen on tinkering with the existing resolution in such a fashion that it complies. And the reason that I'm not keen on doing that is because it requires so much guesswork on our part that I'm not sure we are really capable of doing that. I think we simply need to send this back and have Planning and Zoning take another look at this in the light of our discussions, and maybe later on we can give them some direction on. But that's not before us right now. I would like to see it simply sent back for a new consideration by the board, by the Planning and Zoning Commission, and see if they can apply the code requirements of .55 130A and .50.320 in such a manner to the facts that the two of them tie together. In other words, that the decision that they come to can be easily understood to be based on the requirements of the code and is supported by the evidence that was presented. And I don't think we are capable. It would be such a monumental task that I don't think we would ever be able to comply with this and to provide a proper answer. So for that reason, my druthers would be to send it back. But I'm open to hearing your views on this. And remember, there's no motion pending at the present time. We're simply discussing this before we make a motion. Mr. Stewart.
I would rather send it back, because if we try to correct the error, then what we're saying is the hearing was held and that the hearing constituted due process and that it was fair and impartial. By remanding it, they have the opportunity to make the correct determinations using the code and all the references that are available in the code, because it's spelled out very clearly in the code itself.
So are we requesting that they reopen the public hearing?
No.
Or just simply?
No, I don't think, and by public hearing you mean that people can come forward and testify again. I think we need to make sure that we understood the two different considerations and concepts of a public hearing. But I think you are limited simply to providing people an opportunity to talk again. That's not what I'm referring to. What I'm referring to is that on the basis of the public testimony that was given, and on the basis of the presentation by the department, that they review what they have done and they comply with the code, which is apply those two crucial sections of the code to the evidence that was presented, and either vote it up or down on the basis of that. But their decision needs to reflect a discussion of the specific requirements of all elements of those two code provisions.
Right.
That's what I have in mind.
Okay, there was just clarification I was looking for.
Okay.
I think there's also the issue of some of the staff packet and what was provided. I think it was deficient and very possibly mistaken in some of its direction. And at some point or another, we need to discuss what are we sending back. And if we were just to approve a motion and walk away, I don't think that leaves us much better than where we are now. So we certainly have a lot more work to do.
Most definitely, I agree with you. I think we would not be doing our job adequately if we simply walked away after having said, you need to listen to this, you need to do this over again.
And with that said, then it simply is fair to the Planning and Zoning Commission with good direction, a different staff packet that I think fleshes these issues out a lot more than has happened thus far.
Good.
Then they will be in a better position to be able to make deliberation. I think it's very clear in the record. They're especially having postponed or postpone the public hearing and reopen the public hearing. They were wallowing and trying to figure out what to do, and despite staff's valiant attempts to try to divine a course, that didn't happen appropriately. And so they deserve that chance to come back with a fresh look and good guidance and see that.
And I think it would behoove us to provide guidance, I must tell you. Okay. Now, having said all this, what concerns me is that this whole process started a number of years ago. And if we were to short circuit this and simply substitute our own decision for that of the Planning and Zoning Commission, any party aggrieved by this immediately runs to Superior Court. It shortcuts the appeal procedure. There's no more administrative appeal possible at that point. By sending it back, we are starting the appeal process, the administrative appeal process all over again. And considering how long it has already taken here, we did the decision in 2015, and we are now in 2017, so we are looking at another 2 years possibly before this is finally decided. Now, that's a burden on not just on the opponents, but also on the applicant. And I am concerned about that, but I must tell you, I don't see a solution to this. Short of us taking on the role of being the public, the P&Z, and substituting our own decision for that of P&Z. And as we discussed before, I'm not in favor of that. So I just do not see an alternative to this lengthy process that will result if we simply send it back. Now, P&Z by regulation is required to consider our decision at, I can't remember exactly what the wording is, but basically in an expedited manner, to put it in simple terms. So hopefully, this being the end of April, hopefully by the end of the summer, there'll be a new P&Z decision on this, hopefully. And then whoever feels aggrieved can then appeal to us, to the Board of Adjustment again. And so it's entirely possible that this will come back to us sometime once P&Z has come up with a new decision. But I don't see any alternative to that. I don't know how you feel about this. Mr. Stewart, what's your thinking about this?
You hit on one of the things that struck me when I first read through this particular case, is that after going through all of this, what truly is a good remedy, I don't think there is a good remedy to this case, because the RAC is already constructed, it's operating. There's no way to really come up with an expeditious way of handling this. I think it needs to go through the process, and the P&Z looks at what they should be doing and hopefully do the right thing and provide the appropriate due process, and then let that be challenged.
Okay. The fact that that Nordstrom's rack is operating while all these proceedings are still going on is in fact pretty unusual. I cannot think of another case where an applicant has simply forged ahead, torpedoes be damned. And that's really what has happened here. It's not our concern. Let the chips fall where they may. We need to make a decision based on the record before us. And the fact that the rack is operating really should not influence our decision one way or the other, quite frankly.
No,
Mr. Adams.
Yeah, sadly, these processes always take time, and I have represented numbers of clients over many years who have been in similar circumstances, not in an appeal situation, but in forestalled P&Z hearings or plating cases or whatever. And the remedy they have, of course, is proceed at risk, which is what they've done. And it's very unfair, but it's also unfair to the public if due process doesn't take place. And the sad thing is that the RAC in this case, Nordstrom in this case, has to deal with the vagaries of whether a public process should have taken place or a public hearing should have taken place. They proceeded at the direction of staff. They found out otherwise through the appeal process, but it's the way it works, and it's sad, and that's happens, but I've represented someone who thought they were working and it cost them $1.5 million right off the table. And, they lived with it and they moved on. And it's very sad, but that's the process we have. And I feel for Nordstrom, but the public's right, I think Superior Court has laid it out. The public's right is paramount.
Okay. Anything you wish to add, Mr. Stewart?
No.
Okay, I have nothing to add. My concern is, and I need to turn to our esteemed counsel, do we need to come up with a conclusion? Or can we simply make a motion to do whatever we want to do now that we have essentially disapproved of the way that P&Z has handled it? Do we need to, in other words, is it a two-step process to get to the remedy, or is it simply a one-step process? You understand what I'm saying?
I guess
We have findings of fact. We passed two findings
Right.
by way of motion. Do we now need to come up with a conclusion, or can we simply move directly to the remedy?
I think that if I don't know if this answers your question or not, so I'll just put it out there and then you can tell me if it does. If the Board of Adjustment decides that they want to remand with guidance and instruction, then you would go ahead and make additional findings and/or conclusions of law to interpret code and have that be guidance. And then after you work through those, then you can kind of do and decide what those are. Then you can say that then you might be in a better position to do your motion to say that the remand should be with these additional provisions, or you could do what you talked about doing. I mean, that you talked about as the alternative, but I didn't understand that you were intending. None of the discussion favored that, but that was to do the remand based on only the two findings that you had. So, if it's easier for the board, you could have another motion that said we're going to remand with some guidance. But since I haven't heard any particular guidance yet, I don't know how you want to
Okay, well,
approach that.
maybe you didn't quite understand what I was getting at. being a lawyer, I like findings of fact and conclusions of law. We have already struck the two words of law, but it seems to me that there still needs to be a conclusion. Having come up with findings, we now need to conclude that the resolution of the Planning and Zoning Commission is insufficient and is of no force? No, we can't say that, can we?
Well, I think your conclusion would be based on those two findings.
Yes.
The board needs to remand. That's your conclusion of law, isn't it? If you're looking for-
No, that's the remedy.
Oh, okay.
That's the remedy. But the conclusion still is that it doesn't comply with the court's order or with,
Or that it doesn't provide a fair hearing. That's where I thought you
Okay.
guys started out, was the
so
you know,
does not reflect a fair hearing. Is that what you're saying? The Board of Adjustment
This is not
concludes on the basis of its findings that the Planning and Zoning Commission's resolution did not provide
oh,
fair.
Okay. Yeah, so I
Yeah,
think
tie
that,
into
so I
the-
had something for you on this.
Okay, tell me.
And I'm sorry if I was still not on track, but it seemed to me when you were talking about 2110-304.
Yes.
That code section and other code sections by other boards are backed up in by judicial doctrine. And so when courts look at this, they say so in this case I'm going to quote from Fields v. Kodiak City Council 628 P2D 927 at 933. It's a 1981 case, but it says that the relationship between evidence and findings and between findings and ultimate action, that's the test. So that only by focusing on the relationship between evidence and findings and between findings and ultimate action can a reviewing tribunal determine if the action below is supported by substantial evidence. And so you're unable to make those conclusions, is what I'm hearing.
Correct.
So the
All right, so-
conclusion could be that the Board of Adjustment, because...
Okay, let's formulate a motion here. And we need to wordsmith this together here. Julia, the Board of Adjustment concludes on the basis of its findings that the relationship between the evidence and the findings and between the findings and the ultimate action
That the record is sufficient.
is insufficient.
That's what, thank you. To establish the relationship
To establish the relationship between evidence and findings. And between findings and ultimate action
is supported by substantial evidence.
is insufficient to establish the relationship between evidence and between findings and ultimate action
Is supported in the record of the case. I mean, I guess I don't...
Yeah, we just need to come up with proper wording here. Can you help us out here? No.
Well, I think among other things, you did something says and does hereby remand, is that what we're?
No. The remand
This is the.
No, the remand
This is-
by itself is the next motion that we will make. This simply is the conclusion that on the basis of the
Based on
findings,
former decision.
it's insufficient what they did.
Okay, I think you said it.
Basis of its finding.
What's wrong with keeping it right the way it is with it, just a period after ultimate action?
To establish the relationship required by code. How is that?
Yeah, and Alaska case law.
Required by code and the court's order. How's that? Because we have not. Or do you want to say Alaska case law? That's fine by me. You already put that Kodiak City Council case on the record here. So that the motion says, let me read it to you. The Board of Adjustment concludes on the basis of its findings that the Planning and Zoning Commission's resolution is insufficient to establish the relationship between evidence and findings and between findings and the ultimate action as required by code and Alaska case law. How's that? Does that satisfy you?
That satisfies me.
All right.
Mr. Chair, could you read it one more time for me?
Of course.
Thank you.
Also for my cohorts here. The Board of Adjustment concludes on the basis of its findings, comma, that the Planning and Zoning Commission's resolution, and needs to identify the resolution, is insufficient to establish the relationship between evidence and findings and between findings and ultimate action as required by code and Alaska case law.
And that resolution is P&Z Resolution 2016-0029.
Oh, okay. All right. Does this motion pass muster with our esteemed council?
Yes, I'm good.
Okay.
It's just 1-0, right?
029, did I say 00?
Yeah,
Yeah,
0 to
just 1-0.
Okay. Are we clear on the motion? All right, I'm the one who made the motion. I need a second.
I'll second.
Mr. Stewart has seconded. I want to cross the T and dot the I, and when there are findings of fact, there needs to be a conclusion of law, even though the words of law have been dropped. And so this is designed to be the conclusion that then leads us to the remedy. Okay? Are we ready to vote? Ready to
Yes.
vote? Madam Clerk?
Mr. Buchow?
Yes?
Mr. Stewart?
Yes.
Mr. Adams?
Yes.
Thank you. Now, let's do one more thing before we take a break, and that concerns the remedy. I think all of us are in agreement that this case needs to be sent back to P&Z for reconsideration. And we have already discussed the fact that we are going to give him some direction, but that, I think, needs to come after we have made the decision to send it back. And my view of the matter is that the way to handle this is that we say, by way of guidance to the Planning and Zoning Commission, we wish to address the following issues. And then we have a laundry list of items that need to be considered. That would be my view of how we should handle this. Does that make sense to you?
Yes.
Okay. So the motion that we now need to craft is simply to send the matter back to P&Z. And Julia, you need to help me out here. Should we say the Board of Adjustment decides pursuant to AMC 2130-095 to return the matter to P&Z for purposes of reconsidering the case in the light of the findings, the conclusions, and the recommendations below? Does that make sense?
Well, someplace I would hope that the board would work in, and maybe I'm past that, but what somehow in there is the standards for remand on the remedies in
Where are the
in your
standards for
code.
remand?
They're in 100. And so, there is insufficient evidence in the record on an issue material to the decision of the case. And so I would think that you would start there. And because you found this one conclusion that it's insufficient, and then you say because the Board of Adjustment has concluded that the evidence is insufficient on the record on issues material to the decision of this case, the case is remanded by the Board of Adjustment to Planning and Zoning with guidance to included in this decision. And then,
Okay, so you would start, let's look at this. And we are looking, by the way, at 2130-100, which gives guidance to this board as what we can do.
and so I would think that it would say because the Board of Adjustment has concluded, because you just did that
Right,
conclusion, has concluded that there is insufficient evidence in the record on issues material.
There's insufficient, just a second, that there's insufficient
Evidence in the
Evidence.
record
evidence. Is it in the record or
Yeah,
in the
that's what it says.
resolution?
in the record.
In
The
the record.
resolution is in the record. Not only is the
Okay,
resolution in the record,
in the
but all
record,
that discussion
okay, in the record,
on issues. This is an issue, but you can
on
do
issues, yeah.
material to the decision of the case.
To the decision of the case.
The Board of Adjustment, comma. the
And
Board-
therefore remands the case.
Well, I started with because, so.
Yes.
So because, then you just need a comma, because
Right.
the Board of Adjustment finds this, comma, the Board of Adjustment remands the case to the Planning and Zoning Commission, consistent with,
No, for reconsideration, consistent with.
yeah, so I was gonna say consistent, you don't have all the other things yet that you're gonna want to be consistent with, so we just say consistent with this, this.
No, for a decision consistent with. It needs to, because the Board of Adjustment has concluded, et cetera, the board remands the case to P&Z
Why can't you just say for
Consistent
compliance
with
for
this.
compliance with,
with the two
With-
code provisions?
for compliance,
Would that work?
Yeah.
for compliance with code.
Yep.
For rendering a decision in compliance with code.
Yep. I mean, yes, sir.
We are not in the military here. For rendering a decision in compliance with code. Does that sound good?
Yes, it does.
All right, so the motion, Barbara, and would you correct me? I will read it, and it will be my motion because I seem to be the wordsmith here partially. Because the Board of Adjustment has concluded that there's insufficient evidence in the record on issues material to the decision of the case, the Board of Adjustment remands the case to the Planning and Zoning Commission for rendering a decision in compliance with code.
I've got that, Mr. Chair.
Okay? You got that too, Julia? Who's going to second that?
Second.
Mr. Adams will second that. I think, in speaking to the motion, I intend to support it because, as I have indicated before, it is not practical for us to correct the Planning and Zoning Commission resolution here. There are too many issues here that the Planning and Zoning Commission needs to address, and they are embodied by basically the two code provisions that we have now talked about several times. And it is my intention that if this motion passes, that we will provide some guidance to the Planning and Zoning Commission in terms of having to focus on particular issues. Okay? So, I intend to vote for the motion. Mr. Adams?
I agree, and I think you summed it up nicely.
Mr. Stewart, any discussion?
No, I intend to vote in favor of this.
Okay. Julia, anything that we should consider, talk about before we vote on this?
No, I think I think you, as Mr. Adams said, you summarized everything.
Thank you. Madam Clerk?
Mr. Guchow?
Yes.
Mr. Stewart?
Yes.
Mr. Adams?
Yes.
And the motion passes 3-0. Before we go to the next phase, which is giving guidance to the Planning and Zoning Commission on a raft of issues that are involved in this case, which I think is only fair for us to do to make sure that they are not sitting there just totally bewildered at what we have done here, but that we are actually providing them with some active guidance as to what they need to consider to come up to a proper decision in this case. Before we do that, I need to take a break. We have been at it for 2 hours. So we are going to have a 10-minute recess. Thank you. All right, we're back on the record in appeal case 2016-1. This is the Municipal Board of Adjustment. When we took the break, I said what we need to discuss after the break is direction that we wish to give to the Planning and Zoning Commission so that they don't sit there in total bewilderment and say, what do we do now? And what I have in mind, frankly, is that we come up with a series of considerations that P&Z needs to apply the facts to, and then hopefully come up with a more complete decision than what they have done before. So, my intention is that we talk about specific issues that we want to refer to them, and Julia will put them on the blackboard, and right now they should be in no particular order, and once they are all put down, then we simply go through them, put them in order, and then formalize it. Does that make some sense to you? To the two of you?
Just sort of brainstorming.
Yeah. And just by way of starting out, the obvious one to me is that they need to consider 2155.130A in significant detail, because that's the basis upon which they need to make a decision. And when you turn to that section, it has 7 separate sentences. My memory serves me correctly.
That's correct.
And my idea is that they should go through that section sentence by sentence, because there are some items there that are not immediately obvious when you read the paragraph as a whole. And so the first sentence is rather obvious. The first sentence is, large retail establishments existing on or before May 8, 2001 shall be deemed to be approved site plans and not non-conforming uses or structures. I think this is a useful reminder to them, to P&Z, that this LRE is deemed approved and it is not a non-conforming structure. And so I would like them to make sure that in their deliberations they understand the distinction between the two. Okay, so drop down first sentence. We then go, you done?
Yeah, so
Okay.
I have grandfathered LRE deemed approved and not non-conforming.
Yes. Second sentence. And it reads, the provisions of this chapter notwithstanding, the expansion, reconstruction, renovation, or remodeling of a large retail establishment existing on this date takes effect, may be allowed only after a limited site plan approval is granted. Okay? So second sentence, limited site plan approval is required in this case. Third sentence. What is required? Oh, applications for limited site plan approval under this subsection shall be processed in the same manner as applications for site plan approval required for new establishments. So, put in there same application process for limited site plan amendment as for original site plan.
Is this a place where we would reference a requirement that the consideration of the public hearing has to be incorporated in that? Would we make a statement to
Yes.
that effect?
Yes. Fourth sentence, and this is one that may require a little more work. No site plan removal application required for interior work only. And what I have in mind here, the reason that I'm stopping at this is, when you look at the memo and when you look at the planning department's position, they say, if it's only interior, we don't get involved at all. And I don't think that is a true statement. Because, as this case indicates, interior work can also affect, or exterior work can also affect interior work, and vice versa. And I think in those situations, it should not be beyond, and is not beyond, the Planning and Zoning Commission's purview to address interior issues. In other words, nothing in this sentence creates a taboo against Planning and Zoning Commission requiring conditions affecting interior spaces when the project requires a limited site plan review. And by way of example, to illustrate what I have in mind here is, if Sears Roebuck were suddenly to block off all access from its store to the mall, to the interior mall, that would be interior work. But I don't think the Assembly had in mind to cut off Planning and Zoning Commission's review or right of review, because that kind of a situation would affect the entire mall, not just the interior space of Sears Roebuck, or whatever they're called nowadays. And I think in that situation, the Planning and Zoning Commission should have the right, and does have the right, and there's no prohibition here that says the Planning and Zoning Commission does not have the right to review that situation and impose conditions.
Yeah, when you look at the code, it very clearly is, to me, is intended to address the interior remodel that anyone should be able to do to move partitions around, as long as it doesn't affect those key provisions
Yes.
of code. To the degree that it starts affecting those, then it has a dramatic effect on all those things and moves it out of conformance.
Yes.
The requirements of the code. At the point it starts moving out of conformance with the code, then it's subject to the requirements of the code.
Okay.
This might be a good time to put in the sections dealing with like 2155-100 that says change is permitted only in the direction of conformity, not out of conformity.
Julia, does that fit in here, or should we put that? No, I think that goes with the fifth sentence. Take a look at the fifth sentence. In approving limited site plans under this subsection, the Commission shall apply the standards set out in 2153-20 in a manner proportionate to the extent of the expansion, reconstruction, renovation, or remodeling proposed.
Exiting narrator.
I think that what Mr. Stewart was talking about, and I don't know if it goes here or not, but isn't the one that you said, but I think he was talking about the general site plan review standards, which,
Yeah.
which, is that what you just quoted to me?
Yes.
At
Yeah.
5,200. And so I don't know where to put that in, but since this is kind of brainstorming,
Yeah.
we'll just put this up here, but that's the backsliding
Okay.
one. So I don't know if it goes here or in
Or
a separate
someplace else.
discussion itself, but let's just get it on the board.
Yeah.
So let's go back to something, because I didn't, you were saying, Chairman Buchow, if interior change affects the exterior compliance requirements, is that where you were going?
I think I was addressing that, but it gets to
Okay.
exactly what Mr. Buchow was talking about, and that is that you cannot have freedom to conduct any sort of an interior remodel with carte blanche to do as you please when it can have a drastic effect on public safety, circulation, any of those other standards that we require of LREs.
And so then that was what you were saying, if it moves the LRE, even the grandfathered LRE, out of conformance, if an interior remodel moves the LRE out of conformance, then
Then P and Z should have a right to review.
yeah, then P and Z review is triggered
Yes,
under this section that we're talking about.
correct.
Okay, and then I think that's what led Mr. Stewart to note here that also has a tie into 2150-200.
100.
Oh, 100.
I think what does merit
Or is that-
discussion in our...
I think it's 100. Let me look at it again.
in our direction, I think one thing that's merited
5155.
is reference to Mr. Weaver's September 2nd, 2009 memo, where he's providing an interpretation, but he doesn't have that latitude.
Well, I think we need to address that separately.
Okay.
I want
Well, I'm
to,
just going to put it down here, and then we can move it someplace else.
Yeah.
Since you said we were brainstorming.
Yeah.
So that's the
Weaver-
2009
Weaver
memo.
memorandum. Okay, are we at the fifth sentence, or have we already talked about the fifth sentence?
You were at number 4, so now you've got to
Okay.
go to number 5.
Number 5 is, in approving limited site plans under this subsection, the commission shall apply the standards set out in 2150-320 in a manner proportionate to the extent of the expansion, reconstruction, renovation, or remodeling proposed. Proportionate application of 2150-320. I think that's how we should entitle this.
Say that again?
Proportionate application of 2150-320.
Okay.
Number 6.
Yeah, how about number 5?
That's what we
Oh,
have.
that was 5, I'm sorry,
Yeah.
I misnumbered.
So number 6, the cost of compliance with the standard set forth in 2150-320 shall not exceed 10% of the cost of expansion reconstruction. So entitle this 10% limitation issue, 10% cost limitation issue. And the 7th sentence is the 5 issues to be considered in the last sentence. I don't think we need to go through those in detail, but simply list the 5 considerations.
Can we call those?
5.
Like
5.
mitigation?
The 5 what?
Mitigation?
They're not necessarily mitigations. Five issues to be considered. Let's say 5 issues to be considered.
You don't think there's standards or criteria?
call them criteria, I don't think,
Criteria.
5 criteria spelled out in the last sentence. Where do we fit in the backsliding issue? Should that be a separate heading?
I think we addressed that through number 3, was it?
You have backsliding somewhere.
I put
But
it
I
under
can't
number,
remember where.
I put it under number 4,
Okay.
because, and I also have the 2009 memo,
That's, yeah.
right under number 4.
Now, under the 2009 memo, is that where we also need to include something relating to municipal rulemaking in, rather than?
Well, that ties in
Or
with the
that
memo.
ties in, okay.
Yeah, yeah,
Right,
yeah.
but he's just saying what we're gonna do, so municipal rulemaking.
Okay,
Okay, so one thing that.
what's
that,
missing?
And I was thinking about number 7 when you said it, and why I was saying criteria, is that in looking at it, it says that in determining the degree to which the standards in 2150, 320 shall apply. So you had you had the proportionate one, which was number 5.
I think so.
And that also implicates 320. And so the question is, do you want to look at those two together, since they're both seem to address what P&Z is supposed to do when they're applying 320?
Okay. Can you lump them together?
Well, I think that just for terms of, for the board's discussion, you're going to be addressing presumably the relationship between those two. That when P&Z is instructed to look at the limited site plan reviews, they're supposed to apply the standards set out in 320, so we know that there's a litany of standards in 320, and they're going to apply those in proportion,
Yes.
in a manner proportionate to the extent of the expansion. And then if you drop down to that number 7 that you just said, it says in determining the degree to which the standards in 320 shall apply to the project. That's not to the whole, I mean, that's to, the site plan review. The commission shall also consider.
5
And then that's why
separate.
I called them the mitigation factors, because, in my shortcut here, because this says you gotta go do it in proportionate, and then this says, and here's some criteria to help you do that,
Okay.
right?
Yes.
Okay.
True.
Yeah, so when when we go through the discussion and lumping things together, that's,
Yeah.
I was just thinking that you would have arrows for those two, is just what I was saying.
Yeah. Now, the Weaver memo and the requirement of rulemaking should be a separate point altogether. I don't want that lumped in with anything else.
Okay, well, in some, I think that what the connection there was, that what I heard somebody say is, you got the rulemaking part, but why they brought it in is that there are things in that memo that you discussed earlier were being applied.
Right.
And so, an interpretation of this criteria. So somehow that memo is going to be implicated in your consideration of these all the way through, but the actual rulemaking you want to take over here, is what I'm hearing.
Well, they have to have some rulemaking because that, basically that 2009 memo is invalid.
Yes. And so that's why I wanted to be a separate item altogether, that we say, because they didn't adhere to the rulemaking provision, that memo is
It just-
invalid. And in any event, it doesn't make sense because it talks about a 10% limitation that really doesn't apply. We need to talk about the 10% limitation issue somewhere.
Okay, so you have that under number 6,
Okay.
the 10% cost limitation issue.
Right.
So I guess what I'm not, so now you'll decide sort of the order that you take them in, and it seems to me that you either want to take the rulemaking memo first, or it's going to be
Stick it,
implicated
yeah.
in a bunch of other things.
So what you're saying is stick it way at the beginning.
Well, you might, if what I'm hearing, what I'm hearing is people saying that it's not valid, and so someplace you're gonna have to.
Well, I think that, what's germane to a lot of this is that they received inappropriate direction from staff. And it may be appropriate to say, first of all, corrections must be made with direction provided by staffs.
Good idea,
Specifically-
such as inappropriate guidance from staff, such as the memo, the 2009 memo.
which provides direction or guidance that was inappropriate, or not inappropriate, but was out of.
Well, I think we need to say it's invalid because it wasn't promulgated in accordance with rulemaking.
Yeah, but substantively speaking, we want to also say that substantively speaking, it's wrong.
Yes.
Remember? It's not just the fact that it was not properly adopted.
Yeah.
And it
It's
was
more than that.
misinterpreted.
Yeah,
It's
Just say it wasn't promulgated in code and it is wrong.
it's just flat wrong.
Yes.
Yes. But then, once we have said that it's flat wrong, we also need to tell them in what way it is flat wrong.
Right. And we can do that.
Okay. All right. Anything else that we need to address?
There's one thing that bothers me a little bit on the proportionality issue.
Yeah.
And I'm just thinking out loud now, if they treated the RAC as a power center similar to places downtown, which they talked about a lot on the record, does that, the fact that they're looking at it more as a power center rather than part of the mall, because the staff also said it's really not part of the mall, does that increase the proportionality because of the greater effect?
Oh, God. I hadn't thought about that, I must tell you.
That's a concern for me.
So there's so I didn't get up here what, or on my pad, what I heard Commissioner Adams say that about sort of these two,
That they
And-
receive faulty direction from staff.
Yeah, so-
We need to start out with that.
receive faulty
Okay.
direction, and then, and you were talking about the memo at that time, but now I'm hearing, Mr. Stewart say there's also other places in the record,
Yeah, in the record and in the transcript.
places in transcript and record where direction was faulty. And one of those that he's identified is the
The
discussion about
power
the-
center concept.
Power center.
Power center, but even more importantly, no matter how they described it, this concept that somehow came down, you believe, to, I'm hearing you say, to the Planning and Zoning Commission, that staff said the rack was treated,
So they said it was not part of the mall.
it was not
That-
part of mall. And that sort of is the problem, because they got direction in code on what to do about what site plan amendments are. It was filed as a site plan
Yeah.
amendment, and so
Okay.
So I think, no matter what order you take them in, we'll take notes and make findings. And then you can reorder them,
Well,
or
I would like to start out with this issue. the
about
faulty-
the
the faulty advice.
Okay, so let's go.
Okay.
Yeah.
Okay, so the first advice we should give them is that they receive faulty advice. How do you envision us giving them some direction?
Well, I think, first of all, we need to say that this memo is, provides no basis in law, and the guidance is in conflict with municipal code. And it was not subject
I'm
to
trying
proper
to
rulemaking.
I'm trying to step back a little further, and that is, how do we direct this to P&Z? By way of, and Julia, you need to give us some assistance here. How do we raise all of this? Do we simply say, once we have done the decision now to send this thing back, do we simply then say, and by way of guidance, of giving guidance to the Planning and Zoning Commission, we would like, or the Board of Adjustment would like P&Z to consider the following?
You might think about making a motion first, and that would be that you're going to exercise your authority to, that you have under code that P&Z doesn't have, to interpret code and add construction to that. Pull up the code, but that's what it sounds to me like you're wanting to do. The board, P&Z wants to do something with code, they have to do with regulation.
Yeah.
But the Board of Adjustment as a Board of Appeals has the ability, and you have,
It is somewhere.
I
We
always
need to-
put the references at the.
We need to dig it out.
Right. Yeah,
Too many tabs here.
Are you talking about 2130-090B,
probably, that sounds.
independent judgment?
Yes.
On matters that relate to interpretation and construction of ordinances or other provisions of law.
Which section do you look at? Are you looking at?
21.30.090B.
May exercise its independent judgment on legal issues raised. Is that what you're talking about?
Yes, that's what I was.
Okay, that's the scope of the review. 2130-090.
What?
B,
So,
capital B.
yeah, so the Board of Adjustment may exercise its independent judgment in legal issues raised by the applicant. The term legal issue as used in this section means those matters, the print is so small, those matters that relate to the interpretation or construction of ordinances or other provisions of law. So, but it seems to me that it sounds to me like you intend to exercise
Yes,
the authority that you have under
under that section.
to provide P&Z with interpretation and construction of ordinances and other provisions of law to assist them on remand.
Yes,
So you would do that, and then you'd have a discussion here, and then you would give those rules to them that you come up with here, your interpretation. So one of the things that you've already talked about is that, I don't know where you want to, it didn't sound, Mr. Chair, that you wanted to start with this one off the top, but it was just included in the panoply of things here, was that municipal rulemaking is, that the memo doesn't have the force of law because it wasn't exercised, it wasn't,
right.
whatever that is, it wasn't promulgated as a regulation as required by code. So that would just be one of different findings. So you can take wherever you want to start, you would, it seems to me that at the end, I guess my counsel is that you give planning and zoning as clear as you can what you think the law is. Don't worry about it. Don't let it go. Don't spend the whole memo talking about what they did wrong.
No.
I mean, it's just in briefing. It's and other legal exercises. So much time is spent disputing what was said. He said and it seems to me that you have some clarity here that you want to share with them. So go with the clarity that you want to share, and then at the end, if you want to say, to the extent that they receive advice to the contrary, they're to follow your advice. I mean, that's the gist of it.
So we start out by way of preamble saying that pursuant to 2130-090B, the Board of Adjustment exercises its independent judgment on legal issues raised in the case, simply in the case. Number one. Jerry Weaver's memo of September 2, 2009.
Yeah, it's entitled the Planning Department.
Planning Department, yeah, whatever it's
memorandum.
called. Planning Department memorandum. Does not have the force of, not the force of law. Should not be a guiding, should not provide guidance to P&Z in this case because it was not adopted in conformance with whatever the rulemaking ordinance is. We'll come up with that in a second here.
Sure, I think you could say misapplies the 215320, inappropriately applies the conditions of 215320.
It wasn't 320, it was 130A.
130, I'm sorry.
Yeah.
138.
Hold on. And then there were,
You can see misapplies the criteria and
yes,
does not have the force of laws. It is not codified in municipal code.
but we need to specifically talk about the two areas that the memo addresses. And that is that it holds that interior work is not subject to review by P&Z or by the department. And then we need to talk about the 10% rule. So those are the two areas that the memo addresses. Oh, and number 3, that the 10% dollar figure is to be applied primarily.
Correct.
Well, it's inconsistent because on one hand it says we're looking at architectural standards, and then down below it says we primarily look at vehicular and pedestrian safety improvements, and number 2, blending the exterior of the old facility to the new facility, and 3 is landscaping and drainage improvements. So I'm not sure what in the world.
I think that goes back to what Adam was talking about, where they only looked at those issues that were raised at that last hearing. They didn't address the rest of the issues.
Okay, so how do we incorporate?
Well, there's one other point that I'd bring up about that, is that that's a 2009 memo. It's not even necessarily applying. I mean, this, you have sort of a standard memo out there that apparently was supposed to be applied to every case. It's not just in this case. And so I think that rulemaking idea comes up there.
Yes.
And I think that and that's why that term doesn't have the force of law. They took it as an interpretation of law,
Right.
and it's not. And so I think that.
And so would you then simply leave it at that? It does not have the force of law because it wasn't adopted properly.
Right, and then to bring in what Mr. Adams said, and then to say also that that the board and the board finds that it is in conflict with the board's interpretation of 2155-130.
Misinterprets the application of that provision.
In that, okay, and then we go on to those 2 or 3 points. The question is one of wording. That's our problem right now.
Okay, so,
Which one do you want to deal with first?
Well, I would like to address, just in the order in which Jerry addressed it in this memo, that it's not correct that
Interior remodels.
that exclusively interior remodeling necessarily prohibits review by P&Z. Rather, if interior remodeling has an effect on the entire project, it should enable P&Z, or it does enable P&Z to review the issue.
Yeah, I don't think we necessarily, I mean, not that that isn't worth getting into, but I'm not sure in this case, we even need to go there. In this case, it goes beyond the interior. And with respect to that, that it qualifies for limited site plan review, and that's what opened the door to the public hearing, that's what's opened the door to everything. It does have ramifications, interior and exterior, to everything, and that's what matters. And in doing so, it moves it out of conformity.
Yeah.
And it's not to say that that isn't an argument worth getting into, but I don't know that this is.
I don't think we should. We need to kind of clamp down on it rather than expand it too much.
But they're
But-
still using the 10% in
No,
a
that comes
copious
later.
manner.
That comes later. We haven't even addressed the, we haven't even addressed the 10% yet. We're still on the perceived prohibition of the planning department and P&Z getting involved when there is exclusively interior remodeling.
So, one avenue that you could do is, I mean, so far I took down the two things that we were talking about. The 2009 Planning Department memo was not adopted in regulation and does not have the force of law. Number two, the 2009 Planning Department memo is in conflict with the board's interpretation of 2155-130 and misapplies the provisions in code. Then I think the next step that you might consider doing is just one by one, whether you start with interior or not, give the board's interpretation. This is the interpretation, and then say that it was misapplied, and show in the record where your interpretation was not the interpretation that you find correct was not applied, and P&Z needs to apply that. And so that would be, if you're talking about the interior, let's write down how what I heard Mr. Adams say is that this application, this is an application for site plan review, and it's not excluded by the exemption for interior. Then what I'm hearing Barrett say, and that the board's that interpretation of the board, or the P&Z's interpretation conflicts with that, because they apparently relied on this memo to exclude all interior work from, I mean, that's what's in the record.
Right.
The
But-
people say,
It's in the transcript too.
Yeah,
Staff-
in the
staff was very
transcript, yeah.
explicit.
Yeah, but-
when the commissioner said, well, geez, we understand that this is, I don't know, somebody used the word taboo
Right.
here. And so I think that it's important to lead off with the board's interpretation of code, and then we can, I can
Yeah.
write down.
We cannot get too far afield here. I mean, we cannot put in 50 pages of considerations here for P&Z. It just isn't feasible. So we need to limit this in some fashion and need to be very concise. We have already said that the memo does not have the force of law, number one. Number two, the provision of the memo that strictly interior remodeling does not subject the project to review by the Planning and Zoning Commission is incorrect. In fact, if interior work does affect the entire project, Planning and Zoning Commission may review and mandate remedies that affect the interior.
Well, and to the extent they affect conformance with the requirements of 2155, 130.
Well, when you take the interior and you affect it so much that it triggers a site plan review, then
Yes, how do we put that in words? In a simple sentence? That's the issue here.
Well, I have, if the interior work of, if interior work is so significant that it requires,
limited site plan review.
an
Well,
application.
interior work doesn't require that review.
Well,
Interior work may involve site plan review.
If site plan review is required,
No, it's the other way around.
I don't think so.
If interior work affects the entire project, it may involve a site plan review.
I don't think that's.
I'm not following that at all.
You don't like that? Okay.
Well, I think that, maybe Mr. Adams, you can give me just off the top of your head, and I'm gonna write it down, what you think the provision regarding interior work, your interpretation of that provision. And I understood that to be that, that the exemption for interior work is not,
Applies to those where those effects are held
yeah,
within
does
the
not
building.
apply, does not apply where an application for limited site plan review is under consideration. It exempts interior only projects
And those effects are kept within the.
if the effects are limited to the interior, something like that.
Yeah.
Does
I
that,
like that.
capture?
Oh,
what-
absolutely.
what you were
Absolutely it
saying?
does.
Okay.
Yeah. So that's the first one. Then we need to address the 10% rule. And here, where is it?
I think the confusion is that 10% review applies to those non-conforming aspects of the project existing at the time of application.
no, I don't think it's the project. I think it's the entire LRE.
Yeah,
10%
Yes,
can be used.
yes,
for
yes,
LRE.
absolutely.
I should have said
But
site,
that's-
yeah.
Yeah, that's what they were trying to do in this case, was keep it confined to the
Exactly.
project.
Yeah. to the exterior of the project. Remember, not the
Yes.
interior.
Well, the application that's often used, and I've worked on another shopping center here in town, and whatever they did, it didn't matter. That 10% was applied to everything to bring it into conformance. The new stuff, the old stuff, it didn't matter. It was applied to all of it.
Not just to the
Not-
cost of
Not just
external
those things
portion
that are out
of
of conformance at the time of application.
Wait, so this is one of the things that in the, that Dean Gates picked up, and so I'm gonna share with you his comment, because he's
Okay, tell us.
upstairs, and it says that a conclusion of law VOA may include is that the planning director's 2000 side memo is not controlling and is incorrect. The VOA interpretation of 2155-130A is different. The 10% cost for compliance applies to the whole project once it is determined limited site plan review/approval is required.
The whole project, he means the whole site.
The whole
Yeah, the whole
yes.
site.
LRE as it was approved
Yeah,
in
yeah,
2001.
Yeah, he means the whole site,
Yes.
yes. So does that?
That's a great
does that-
statement.
Okay, so
Yes.
So I'm gonna write this down. The 10% cost for compliance applies to the whole grandfathered LRE site plan once it is determined limited site plan review and approval by P&Z is required. Okay.
But what's key is the understanding that the planning and zoning's conditions of approval, required conditions of approval, they aren't limited by that 10%.
Planning and zoning.
Correct.
Correct.
Planning and zoning, say that again? P&Z's,
Conditions imposed by Planning and Zoning Commission to achieve conformance with code are not limited by a 10% limitation.
Well, but isn't the purpose of that 10% to provide a bridge between the non-conforming uses on the LRE as existed in 2001 and
And what was applied for in the
on the
limited
project application, yes.
Yes, that is true.
So there would be, otherwise, if there's no limitation, then the 10% rule wouldn't protect anybody that was grandfathered in 2001.
Well, until the time they come into an LRE or a site plan review.
Oh, for the entire LRE.
Well, part and
Mhm.
parcel. Proportionality comes into play then.
Yeah. So, what does the 10% rule apply to? Let's see if we can address it in that fashion.
Now, my understanding, for example, the landscaping or the site landscape and the site triangle was their issue.
Those things that are part of the
But-
LRE that need upgrading, that are really
that aren't part of
non-conforming.
that aren't part of the, are you saying that like the site triangles, they weren't really part of the project application, but in reviewing the project application, they came up because
Right.
when P&Z
But-
reviews the project, there are things, and they provided safety issues, so that the 10% kind of
Should not
is
apply
set
to that.
aside.
It
is
goes
set
to
aside.
it goes to that.
those.
Those exterior.
It goes to
Those are the
but-
bridges that.
So
you're talking about.
if then Planning and Zoning Commission requires a sidewalk, anything to bring it into conformity as part of the project, if that's required as part of the project, that's not part of the 10%, right?
That's what I'm hearing.
That's my understanding.
That's what I'm hearing you say, that the 10%, to use your term, bridge. So if there's a project that's gonna create a new wing and of something, and it goes for limited site plan review, and as part of that wing, it goes through review, and geez, they can't help but notice that more traffic's gonna come in here, and we got these site triangles, and down the other end of the thing, we never had a sidewalk down there that really should happen. So it's to put a limit, because if it had, without that, under 200, planning and zoning has to be able to say, under the general standards of review, planning and zoning has to say the project's in conformance. Well, they know it's not because it's an LRE. It was deemed conforming,
yes.
but the gaps between true compliance and deemed compliance are going to come up potentially anytime somebody puts in a project. And so the argument is that when somebody puts in a project, the proportionality and the mitigation factors of 320 apply to that actual addition or remodel.
To the cost of the project.
Well,
The little project.
Yeah.
Those things come into play on how big or small compliance with new code 320 has to happen. So they're mitigating factors, they're just not the 10% one. The 10% factor goes to the limit on the upgrade. P&Z is allowed to say, okay, well now you're coming in here and you're dinking with this project, and now there are all these other things that we're seeing, oh my God, you're going to have impact over here, and the code says, no, you only get to do 10%, and you don't have to use it. It's a limit. It's not P&Z doesn't have to go to the full 10%, but they can't go over it on what they need to have fixed outside of the project.
Right.
Because otherwise, if the code says you're going to apply proportionality and you're going to use these mitigating factors, you can't have another factor like 10% come in and wipe them out. Wipe out the very thing that you're told, that the P&Z is told to do. It can't be they can't be internally inconsistent that way.
Yeah,
Yeah,
the way I read this, that I think is critical, and in defense of the petitioner, they agreed to put that sidewalk in. So that was part of the project, and they didn't claim that at 10%, but they could have made that claim. They have said, well, we'd like to put it in, but it goes beyond the 10% limitation. See, that's the concern I have, is anything, that 10% is for addressing existing grandfathered non-compliance issues.
I think
That's
that's
what
true.
that's for. And so the petitioner is not in a position, did not claim this, but they are not in a position, planning and zoning needs to understand that provisions of sidewalks, assuring conformance with those issues so that we aren't backsliding, but maintain and move towards conformity as part of that site plan review in their new project. If those are required for that project, that's not part of the 10%. Planning and zoning has authority to demand that.
Okay, so let's go back to what you said, the 10% limitation is applied, and then you just said it so fast I couldn't do it because I was listening to the rest of it, is applied only to,
I guess you could say, non-compliance issues that existed prior to the time of application.
the entire MRE.
Correct.
Yes.
For the whole idea.
Yeah.
Yep.
Yeah,
The whole
and it's
project.
fair, I mean, they can't, planning and zoning can't go and say, and by the way, over there, you know where cars used to be, we'd really like to have a sidewalk. I mean, that's all fairness and that's understandable. However, to add to that, planning and zoning is not limited by 10% for those items introduced by the new project that are required to achieve conformity with code.
Yes.
Okay, so P and Z is not limited to,
10% limitation.
is not limited by
By the 10%
limitation.
cost limitation.
Cost limitation on,
Parts of the project that are required to move to maintain conformance or achieve
on the
conformity
remodel.
on the remodel.
Yes.
Project, on parts of the remodel project required to maintain conformity.
Conformity with code.
Oh, okay.
Okay. Just anything else that we need to say about the Weaver memorandum?
I had one
Yes,
question.
there's one more, I think.
Was there one more? No, you had something else?
I had the question come up, which is, it's 10% of what?
Right, that was the other question. That was the other question, is what is the 10%? Does that include the interior remodel or not?
And in my view, reading the code, it applies to the
To
entire
the entire
project.
project, not just to the exterior,
Right.
which is what Jerry Weaver said. It only applies to the
Those
exterior.
parts of the exterior,
In terms of calculating it,
the 10%, correct?
yeah.
Okay, so
So-
10% calculation is to be
Based upon
based upon
the
the
cost
cost of the remodel project.
of the entire remodel project, comma, including interior work.
Okay.
Okay. Anything else we need to do? I think that's it regarding that one. Okay. Now we come to the 7 sentences of 130A. And maybe we need to streamline that and leave out the first sentence and simply say, by way of guidance regarding the application of 130, BOA offers the following interpretation.
Did you want to pick up with backsliding? Because that's, you talked about that a couple of times now in the discussion of other things, and that
Yes.
seems to be the next biggest one.
Okay. And when we look at, where was this? Where did you address the backsliding?
The backsliding wrote under sentence 4 is where had to do with the interior. So I think that you already covered the interior, so that was
Yeah.
the question about it, is where are you going to put it? So I think rather than putting it under any particular sentence, maybe you could just talk about it and we could then figure out where to,
Maybe we just have it as a standalone.
yeah.
Let me see here. You had addressed this, Julia, in issue number 2. For a grandfathered LRE, the 2 sections require the limited site plan amendment to comply fully with standards for a new LRE.
Right, so this is how I interpreted the briefing on this, on appeal. So under what my interpretation of appellant's issue number 2, sort of had two prongs. One was, so for a grandfathered LRE site plan, do AMC 2155-130 and AMC 2150-320 require the project proposed in the LRE site plan amendment to fully comply with the standards for a new retail, large retail establishment. And that seemed to conflate two different principles. One was, for a grandfathered plan, does municipal code require the proposed site plan amendment to be in strict compliance with 2150-320? And so you might want to talk about that right now. We've talked about mitigation factors, so it seems to me on the face of 2155-130 that strict compliance isn't required, because it tells planning and zoning that they're to apply it proportional, and it gives them mitigation factors to do it. So that sort of that one. But the second prong of that was, for grandfathered LRE site plan, the site plan review standards allow the subsequent site plan amendments to remove or diminish existing compliant elements. And that gets to what you're talking about, what, how, that's the backsliding issue.
So we need to, how do we introduce this? How about simply referring to your issue number 2, and rather than make a question out of it?
Yeah, well, it's appellant's issue.
Yeah.
You could work it in under 2155-130 if we wanted to get into sentence 7, number 4, item number 4 in mitigation, whether the proposed design site plan brings in greater compliance or more. And what we could do is have some sort of clarifying language that this does not allow moving further from compliance per that reference. And just work that into number 7 and make that as a modifier to that number 4.
Yeah, we could do that. Oh, one item that we haven't addressed at all is the pending federal litigation. That needs to be addressed in some fashion. But let's get to the backsliding here. Where do we put this?
It could also be a simple statement right at the front that all elements of the project new
Need to
Well,
move further
must-
towards compliance.
they must comply. I mean, all elements of the new project must comply. Must comply
With code.
with code. Inasmuch as this is true, items not in compliance must either maintain compliance or move towards compliance, or maintain existing conditions or move towards
Compliance. Yep. Okay, Scrivener.
Okay, I wanted to look up the.
I think that addresses it very nicely and very simply. We just need to reconstruct it. We both said. We're getting rummy.
He's good at this.
Oh, yeah, he really is.
Let go of my head.
Let me touch you, see if it can transfer by osmosis.
Well,
Mr. Chair,
yes,
I got part of it for you. I missed the middle, but if you would like the,
would you please?
I have all elements of the new project must comply with code. Inasmuch as this is true, items that, and I missed the middle, must move towards compliance.
Must maintain existing condition or move towards compliance. They may not move out of compliance, further from
But
compliance.
is it true that proposed modifications must be totally in compliance with code? Or do they merely,
Well, they have to be found to be in compliance. I mean,
or do they simply move the project further in the direction of compliance?
well, the new project, the components of, my understanding is that new components of the project must meet code.
So when you.
The new part of the
Right, so
project.
let's,
Okay.
so in looking at that, I'm not
Of
sure that.
the code at that time, the old
Yeah,
code.
yeah, yeah.
Right.
Okay, so, I'm thinking that if you look at 2155, 130G, and at the same time, it's not really G, but the last sentence
Of 130.
the final sentence of 130. And you look at that at the same time as you look at the code of 320. That it says in determining the degree to which the standards set out in 2150-320 shall apply to the expansion project, to the proposed remodel, the commission shall also consider. And it has these different, what I call mitigation, because new code applies. We know under 2155-130 that new code applies proportional to the proportional to the project,
Right.
you know, to the remodel. So that says, okay, you know, they don't have to bring up the whole other project. We got the 10%
Yeah.
to do that. But then it says, in determining the degree to which those standards set out shall apply, then that's when P&Z is supposed to consider these things, which the record doesn't say that they consider. So they say whether strict compliance would result in peculiar or exceptional practical difficulties or work at undue hardship. So that's one factor. If it satisfies the intent of the section, well or better. So that's another factor. Whether relaxation of the requirement would impose any significantly greater impact on surrounding properties. Whether the proposed design and site plan brings it into
Right, right.
greater compliance. Okay. And then it says to grandfather existing the large establishments and to set standards for the renovation. So to me, P&Z could go through the new, a new application and say, okay, this is how we're going to apply 320 to the new application using these factors.
Right.
Okay, we don't have that they did that, so I can't, I mean, I'm just thinking that that's what this says that you're supposed to do. Then the question is, and it's so well articulated in the record by Mr. Stallone, who sent a letter. The question is, does that mean, which P&Z apparently thought it did, that somebody could come in with a project that that undoes the compliance of the whole grandfathered LRE and
then
set
spend-
it back to where to backslide it so that there's less overall compliance with its plan than when it was approved when it was deemed approved in 2001. And so those are two separate issues. One is, does it have to comply strictly with code? No, not strictly with code, because they have all these mitigation factors. But can the tail wag the dog? Can somebody come in with a site plan and completely undo the conformity and all the other things that the larger project had going for it, and why can't they do that? They can't do that because 2150-200 says that planning and zoning in all reviews of site plan. This is what the appellant said, that the general code for site plan review still that the authority reviewing the site plan shall approve the site plan only if it finds that the site plan meets the criteria for its approval established under the title. Well, if all of a sudden the whole grandfather's LRE through this proposed LRE amendment, this project, all of a sudden doesn't meet the criteria under which it was approved. It was approved as it stood, deemed approved under that criteria. But if all of a sudden you're backsliding, then the appellants are saying this. How can P&Z make that determination? And so that's what the board needs to decide. If P&Z can make the determination and has the tail wag the dog or not.
Yeah, I think, these 5 caveats or whatever you want to call them, I mean, that's, for example, if you get in, you're trying to do some articulation of the roof, but you get in there and you find, well, but the structure won't support it. Well, but what we can do is do a false front, we can achieve this. That's the sort of thing where you don't strictly perhaps meet the criteria, but you get the intent of the criteria, so that's fine. So that's the strict interpretation. That's why you have those kind of provisions. Proportionality, well, we can do that, but that's going to cost $1 million on an $800,000 project. That doesn't make sense. Proportionality. But I think proportionality also works the other way. If the imposition on the public is also, an accursed safety hazard, not that this is necessarily, but if it creates vision problems or devastates landscape or whatever it is and moves it out of compliance, well, that's not acceptable. So that's where, proportionality comes into play that way too.
Okay, we need to move forward here. I'm looking at the time. we need to address the backsliding issue the way that you had worded it.
So I think that the language that Barbara had, I think we can accept that. I think we do, though, need to ensure that does not suggest strict compliance, that the 5 conditions or whatever that are placed.
Okay, so let's see if Barbara can read that back to us.
The language I had was, all elements of the new project must comply with code in as much as this is true. I'm not exactly sure I got that right. And then it went on. Items that must maintain, must move towards compliance. So I'm not sure that that's very helpful after what Julia said. I'm sorry.
Maybe what we need to do is to, as part of, as a mitigation, I'm sorry, as a way to ameliorate strict compliance, these 5 sections or subsections are in fact things that give flexibility to P and Z, but we want to make sure that that flexibility doesn't go towards nonconformity.
I think you could say some effective, while the intent of 2155, 130 is to provide some flexibility in planning zoning decisions, this is not latitude to move
Away from conformance.
Okay.
It still needs to
Okay,
move.
so got
I
that
think
close.
that's a better way of putting
So
it.
intent of 2150-130 is to provide, as appellees have talked about, a flexible framework,
Of review.
flexible framework for review.
For review
Um,
and not strict compliance.
Well, you just say, yeah, compliance, but what was the next part that Wayne, that
But it
you
is
said?
not provided to move away from compliance.
But the flexible framework
does not provide latitude.
Does not
Does
provide latitude to
not
move
provide latitude
to
to
move
move the
further.
grandfathered
the grandfathered LRE
LRE
further from compliance.
further from
Compliance with code.
as of, further from compliance as of May 8, 2001, right?
Okay.
Right.
Because that's when it
Yes,
was deemed.
As
correct.
existed.
deemed,
Correct, that's when it was
Okay.
deemed to comply.
So I have, again, the intent of 2155-130 is to provide a flexible framework for P and Z review. But the flexible framework does not provide latitude to move the grandfathered LRE further from compliance as of May 8, 2008.
Okay, and you are specifically talking about the last sentence of 55-130, right? We're not talking
I'm
about
gonna
the
ask-
entire,
ask-
you're not talking about the entire section. You're simply talking about the last sentence and the considerations contained in it.
Right, this could, and as far as I'm concerned, that could either be in this preamble that we talked about as a standalone, or it could be a modifier to number 5, which I think it stands either way.
The modifier to number 5?
On 2155 to 130. The grandfather existing retail and says standards for the renovation is pretty good.
Oh, the last sentence.
Yeah,
The last
last sentence.
sentence, okay, the
Right.
5 criteria.
Yeah,
Yeah,
Okay.
sorry, not.
Okay.
not
So-
sensible.
so- go
The
back.
intent
Of the last sentence,
of the last,
sentence of 55-130
and
the 5
criteria.
5 criteria contained in that sentence, or that
Just
are
the
part
5
of the
criteria,
sentence.
that the 5 criteria.
And the 5 criteria. Okay.
Yeah, and the 5 criteria.
Well, I
The
wouldn't
intent.
call those criteria.
Okay, and the
They're
5
called,
There are 5 considerations.
and the
five
5
considerations. okay.
Okay, the intent of the last sentence of 2155-130 and the 5 criteria, they're enumerated, right?
Yeah, 5 enumerated criteria.
Is to provide a flexible framework for planning and zoning review, comma, but the flexible framework does not provide latitude to move the grandfathered LRE further from compliance as of May 8th, 2001.
Yeah, I think we got it. Hallelujah. Okay, next. What do we still have? I had one that concerned me. Oh, I know what that was. Go ahead. Take it on. So, going back to the notes here on the blackboard,
Yes,
Julia.
yes.
We have covered number 1 on the left side.
Receive the faulty direction,
Yeah, we addressed that.
okay.
Okay.
So I don't know that we've gotten, did we get that part about?
Yes.
Transcript about the power center and all that? Jeez, I missed that.
No, I don't think you missed that. I think we've addressed that.
You did?
Haven't we?
We talked about that, yes.
Yeah, you sure did talk about it. I don't have any kind of a finding or anything on that, but that's okay. We can try and pick that up later. Right?
Well, the discussion was
Discussion.
proportionality, right? And that's where it got into that discussion. I don't think we have anything on it.
Well, I think there were 2 different things. One was the
We-
treating it as a power center and not part of the mall. That was part of the, well, there's 2 things there. One was based on advice, and one was something that they picked up and
I'm
compared
just gonna
it.
circle this for right now. We certainly
We
tackled the
addressed the memo.
2009 memo. I'm not
Yes.
clear that this.
Okay, all
got
right.
in there, okay.
Then move to the next one.
Okay, that, in detail, so we had the grandfathered LREs deemed approved and not non-conforming, the limited,
Okay.
so, you know, you said we might not have
Yeah,
to
I
be so
don't think we
specific
need
on
to address
that.
that.
So I'll just kind of check there. The limited site plan approval by P and Z is required, okay? And I think you talked about that because in the sense that in why you're doing the remand is that that's P and Z. You know, that's a special thing that they stuck in for P and Z to do.
Yeah.
You know, to do all those factors, not staff or not, you know, it's a limited
Yeah.
site plan review by P and Z to apply those factors, okay. Same application process for limited site plan review as for new standards. Includes public hearing. No limited site plan review application for interior work only. Well, you definitely got that one, right?
Yep,
Exterior work can affect interior work and vice versa.
I thought we covered that.
Nothing creates a taboo. I'm not sure exactly what happened totally about the
Well, we
interior
need
work,
to-
but I'll just
Yeah,
recheck.
we need to
Yeah.
take a look at that.
Okay. For interior spaces, if there's an application that's, okay. So I think that this thing about the exterior work and affecting that is put into the backsliding. I
Yeah.
think instead of sticking it here, you've addressed it, because you've said that if the project's not good. But anyway, if interior change affects interior, compliance required, if,
Have we, okay. I can't read it.
okay, so this is if interior change affects interior, these were all the reasons why that balance of is not a taboo, and if interior change affects interior compliance requirements, then
We covered that in the memo.
yeah, I think so. Okay, but if no effect to key provisions, no carte blanche. If the interior moves the LRE out of conformance, then P&Z review is triggered. So those are some other issues that you were, kind of talking about. If the
That we need to give guidance on, yes.
well, I mean, I guess my question is on this: if an interior solution moves the whole LRE out of compliance, but you don't have an interior only solution here, and I think you just want to make sure that there's no, what I'm understanding you saying is if the project, if the site plan moves the whole project potentially out of conformance, there's no carte blanche against P&Z looking for interior solutions. Is that what you're
Yes,
saying?
correct.
Okay, so maybe we need to pick that one
Yeah.
up better. And now you've covered the
Backsliding.
the backsliding.
Okay.
And so I think that these were just different ways to try and get at the no carte blanche, but I'd say let's go there.
Okay, so that's an issue that we need to address.
Yeah, so that's now let's talk about the interior, now let's talk about the interiors, interior solutions. The P&Z probably would have been able to talk about interior solutions.
Had they not been,
And they would have made some decision, pro or con, about interior solution, had they not been told that, instructed by staff, that that the interpretation offered outside of municipal rulemaking was that they couldn't ever even
Consider
think
it.
about the
Yeah.
interior. And so,
No, I think there's in the record, there's a whole other thing going on where we have a petitioner who's been instructed and has an understanding, everything interior is provided.
it's off limits. Yeah.
So we have an appellant who is trying to resolve some solution, but there's no onus on the appellee to resolve that, because planning and zoning can't tell him what to do. And so part of the relationship in a lot of planning projects doesn't happen at planning and zoning. The best projects happen before planning and zoning.
Mhm.
Planning and zoning, actually,
Yeah.
the best projects are de facto approvals because all the parties have come to some resolution. And that's what gets removed by that memo that is very troubling, is that relationship is wiped out. And, that, I don't know that what we're doing is going to resolve that, because it's that, will the appellee be find this as a reason to open that door again? Will the appellant push that? I don't know. That's their business. But, that's where I think, to do good work, to the degree we can influence that, I think is good. And so I don't know if our language can do
But didn't we address that already?
Well, we
I'm
have the
I'm getting
planning
confused
commission.
at this point as to what we have already
Okay,
addressed
so
and what we
let's go
haven't.
through what we have in
Okay.
this section, not the other three that we did before about getting here, but I have
Correct.
number one, the exemption for interior work does not apply where an application for site plan review is under consideration. It exempts interior-only projects and the effects are limited.
Where?
If the effects are limited to the interior. And so, so that's, okay, so I'll read the rest of them, but I mean, I think that,
Yes.
I think you need to do another thing about carte blanche, because I don't see it in that one. Okay, 2, the 10% cost for compliance applies to the whole grandfathered LRE site plan. And it is, I can't read my own writing. Site plan, it is determined and it is, okay, the 10% cost for compliance applies to the whole grandfathered LRE site plan.
Yeah.
When it is determined that limited site plan review and approval by P&Z is required.
Okay.
Once, that's.
Once it is.
What,
No.
once, that's what was my word. like,
Yes.
Okay, once it is determined limited site plan review is required. The
Okay.
10% limitation is applied only to the non-compliant issues prior to the time in existence, prior to the time of the limited site plan application. P&Z is not limited by the 10% cost limitation on parts of the remodel, renovation project required to maintain conformity with code.
So that's the one piece that's missing right there.
Then the 10% calculation is to be based upon the cost of the entire remodel project, including interior work.
Okay.
And then the intent of the last sentence of 2155, 130, and the 5 enumerated considerations is to provide a flexible framework for P&Z review. But the flexible framework does not provide latitude to move the grandfathered LRE further from compliance as of May 8th, 2001.
Okay.
So I think you can go back up and look at, now you've gotten that far, to the exemption for interior work does not apply where an application for limited site plan review is under consideration.
Okay.
It applies. Oh, it provides an exemption for interior-only projects if the effects are limited to the interior. Okay, so then I think you have this other side of it, which is the that it also doesn't, the exemption for, interior work in the, in the fourth sentence.
Of 2155, 130, 130.
Is, does not
extend to,
Well, does not serve as a prohibition.
oh, yeah, does not serve as a prohibition
For P and
Z
Z
review.
to consider interior solutions
Where,
it's interior solutions in, when P and Z is reviewing remodel project compliance with AMC 215320 and 2155,
130.
130.
Okay?
That's good.
Is that
Yeah,
what, is
that's
that what
good.
you wanted?
Yep.
Okay.
That's good. Okay. What else do we need to cover at this point?
Well, we had the issue that, that appellant brought up as I had as their fourth issue that they briefed, which was, is Planning and Zoning Commission Resolution 2016-29 invalid because the plan modifications are the subject of a federal dispute?
Oh, that's,
the thing that you
yeah,
wanted to
that's
talk
simply,
about.
yeah, we simply say, as to that, the Planning and Zoning Commission is not to consider dependency, or take into consideration in reviewing this case, dependency of an action in federal district court or whatever it's called.
Well, one of the things that the board did the last time when this came, was sort of issue, the federal court case, the planning and zoning,
That's
the
mine.
Board of Adjustment didn't know about the federal court case, and they
No, it
looked at
wasn't
this
pending.
case in 2015.
Right.
But the subject of the pending federal case, which was a dispute over declarations and
CCRs,
covenants.
yes.
Yeah, so it seems to me that you can conclude that again, because this is a new appeal, that adjudication of disputes over property declarations and covenants are non-jurisdictional to Title 21 land use boards and commissions. And
Yeah.
that while a court order on the merits of the dispute could be relevant in evidence if it inhibited code compliance. Maybe you actually had a code, an order, but
Right.
here, allegations about the existence of a dispute outside the jurisdiction of municipal land use boards and commissions are too remote for consideration.
Are they too remote, or are they simply not applicable? I mean, I don't think it's a matter of remoteness. I must tell you. I would, look, that was issue number 4 that you had.
Right.
I think we simply need to say, regarding dependency of litigation between the applicant and, is it the, what's the
Well,
relationship?
I don't know, so the applicant and others
And others, okay.
regarding dependency of litigation between the applicant and others, do you want to say in federal court?
In federal court,
Well, state court would be the same.
yeah, but it is pending in federal
Well, if
court.
it's
for
in
this
state
case,
court.
okay.
Yeah, but it's in federal court.
That's fine.
Assertion that site plan amendments violate CCRs do not empower P&Z or BOA to adjudicate a dispute over CCRs.
Okay, the assertion of,
The assertion that that site plan amendments violate CCRs do not empower Planning and Zoning Commission or the Board of Adjustment to adjudicate such dispute and period, and then we need to add a sentence that P&Z's authority extends only to whether or not the proposed site plan amendment complies with code or not.
P&Z's authority extends only to whether
To,
the site plan.
yeah, to determination whether the site plan, whether the proposed site plan amendments comply with code or not. Does that make sense?
Yes.
Yeah.
the
Basically
only
saying
thing
it's
that-
non-jurisdictional.
Yeah.
Yeah, I mean, I would like to have that be.
You would like that, you like that word?
Well, I like the word non-jurisdictional because I don't think anybody was, I don't think even the appellants in their most urgent pleas to the court were asking P&Z to adjudicate those. The appellant's briefing was, geez, this was going on, we told you this was going on, how come you didn't do anything acknowledging this was going on? And so I think that stating that the pendency of litigation between the applicant and others in federal court
Could you say it's
Did not
non-jurisdictional to P&Z
empower
Or
anyway?
it does not give P&Z or the Board of Adjustment jurisdiction
yeah.
to adjudicate the dispute. And then, but then we also need to continue that the decision by P&Z should not be influenced by pendency. No? We're getting rummy.
Well, I think that why this comes up is that it's the issue. And
What are
the
you?
issue was that somehow the P&Z resolution was invalid because the plan modifications are the subject of a dispute. And I think you want to say no. That the pendency of
Litigation.
the plan modifications doesn't affect P&Z jurisdiction. I don't think it has to be too complicated.
No, what, I agree. So you want to simplify this?
Yeah.
Okay. Try again. Looking at what you have there is number 8.
Okay. Then
I think we're all in agreement, we're just simply searching for proper verbiage.
Yeah, basically, so it doesn't get misinterpreted at the lower level.
Yeah.
Keep it simple, I'd say. Yes.
well, you're sending you're already remanding for other issues.
Yeah.
in the thing. So, you could say that, another way to do it is to say that you're remanding on, for other issues, and then just reiterate that disputes over the CCRs are non-jurisdictional to P&Z and the land use boards.
Yeah.
You don't really have to go farther than
Yeah,
that. You're
but what
sending
does
it
that
back
mean?
anyway.
What does that mean to the people on P and Z? So I would like to be more direct and say you're not to consider the fact
Just
that
say
there's an
that.
allegation.
And just say that.
Yeah,
It's not jurisdictional of the board and shall not be considered by P&Z.
yeah,
And shall not be considered.
and shall not
Oh,
be considered.
Yeah.
Yeah, I think that's fine. Okay, now, have we covered everything that we wanted to cover?
I think you covered the things you put up on the board. I'm just checking to see if you covered every issue that the appellants raised. So,
Well, let's take a look.
so I think that's the
We have covered issue number 1, for sure.
right?
We have covered issue number 2. How about issue number 3?
Well,
Is it
issue number
violation?
3 was sort of was a different way of restating issue number 2. So, and I think that the sub-issues that I thought
Right.
were related to that were what's meant by backsliding, is there a monetary limit on new construction compliance? Does P&Z address standards imposed? And you've already said that that has to go back to that, so.
Right.
And so then 4 is invalid because the site plan modifications that you just took care of.
Yeah,
So, so I think
I think we've
got it,
We've
enough
got it
for me
covered.
to take a crack at it.
good luck.
Not tonight.
No. But you have time to work on this tomorrow?
Yes,
Okay.
this is all I'm working on. And this is all I'm trying to work on.
So then coming back to the time, just to reiterate what we usually do, you draft a proposed decision, and you and I both know, and we all know that there are other sentences that need to go into the boilerplate stuff, what I like to call the boilerplate stuff that needs to be added. And then you usually send it over to me and I take a quick look at it. And then you and I discuss any additions or deletions or modifications, and then it goes to the board. So that's how we usually do this. So the question is, can you do this so that we meet, so that I can have a draft by tomorrow evening? Late afternoon?
Yeah, I think that.
What's your situation?
I think that I need to lock my door and just work on this
Yes.
tomorrow and ignore anything else that comes up. And I think that, and I can ask others to try and lay off copying me on incidental things that come
Yes,
leaping into
and don't
my-
drink too much coffee tomorrow.
tonight. No, I actually haven't had any coffee this week.
Wow.
I'm,
Okay,
Yeah.
so then,
Barbara has something she wants to say.
yes, ma'am.
Mr. Chair, I would like to make a special request that you please give Julia dispensation tomorrow from 12 to 1 to attend her going away party.
Does it involve alcohol?
Municipal building, it does not.
Oh, good.
From 12 to 1, we're having a Hawaiian theme going away
Okay,
party.
okay.
So of course, you're all welcome to stop by.
Well, thank you. But you know, I had not said that she is to work between 12 and 1 anyway. So the only thing I would like to see is a draft of this by tomorrow afternoon, late afternoon. Because my thinking is, there's no reason for us to get back together tomorrow. You're going to be working on this, and then I take a quick look at it, we make some changes, and then on Friday, we get together and hash this out once more. And that gives you a little bit more time too. You
Yeah,
can even drink coffee on Friday morning.
yeah.
Does that make sense? And I'm trying to accommodate your schedule, that's
Right,
what I'm saying.
yeah, I think that makes sense. I think that, yeah, I guess my only worry is we meet at 4 o'clock and we
On
have a
Friday.
session like this, and there's just too much for me to get done on it because,
Okay.
you know, that's my only worry about it. But I don't know how
So-
far along I'm going to be. It takes a certain amount of time to put this stuff in there, and then it does actually take time to rearrange all the boilerplate and put it in there. I mean,
Okay,
there's
so,
it's a
so would you
thing, so-
prefer for us to meet tomorrow at 5:30?
Well, I'm thinking that there's no point in canceling the meeting at 5:30 until about 4 o'clock tomorrow. Is that terrible?
Well, you know my office is right around the
Yeah,
corner, so I
you're
don't
close,
care.
and people made
But-
accommodation for that, and then by 4 o'clock, and maybe before, but by no later than 4, you're gonna know how close we are to that.
But what
I
you're
think it's
saying is,
unrealistic to be,
so what you're really
Rather
saying is
unrealistic.
that if we have a discussion on the draft that you're going to be preparing, it could take some time, and you may need Friday morning to redo the
that's what I'm
draft.
worried about, but I don't
Okay.
know if I'm gonna get everything done by 4 o'clock anyway. So let's go with your plan at 4, and just, on Friday, and just work to that. Because, I mean, it's gonna be.
But that doesn't accommodate if we suddenly get together on Friday and we've got all kinds of changes. That's not gonna work. You see what I'm saying? Because Friday is the drop dead date. So we do need to meet tomorrow. So let's simply meet tomorrow at 5:30 on your draft, and just leave it at that.
Whatever I got
Yes.
by 5:30.
Yeah,
Okay.
does that make sense?
That'll at least cut down what we might have to redo on Friday.
Exactly. So does that make sense?
Yes.
All right. Barbara? Did you hear what we finally
Yes.
hashed out?
Mr. Chair, that is fine with me. The notice doesn't need to be changed. I would be happy to be here and let anyone from the public know that we are not meeting. I would like to ask, and I don't know the answer to this, I've gotten your last 3 motions, or 3 comments, your 3 guidance is what I think
Yeah.
you called it. Do you need a motion for that before we?
Well, that's a good point.
That, my thinking was that we put in terms, that we say substantively, whether by motion or not, that the Board of Adjustment exercises its authority, its rulemaking authority under whatever the section is, to
Or you-
interpret sections of
Yeah,
code.
or you could just have a motion that says that the decision, that the board would like the decision to incorporate the findings, 1 through 7, we had like 7 of them, but the findings that the board has discussed here in the decision. guess I
Would
don't
you
know
like me to
where we
read that
got.
back to you?
Yeah.
Why don't you do that?
Yeah.
The board moves to have the decision incorporate, and I've changed that to the guidance the board
Yes.
has discussed here.
Yes. All right.
So moved.
And Mr. Stewart second that. And I don't think we need any further discussion because I think it's obvious that that's what we want to do.
Mr.
And-
Michelle,
Yes?
Mr. Stewart,
Yes.
Mr. Adams.
Yes.
All right. So have we covered all bases for tonight? If not, since we are going to be here at 5:30 tomorrow, whatever has been
Right.
glaringly overlooked
Right, we'll come
will
about.
be covered tomorrow. We are not like P and Z and simply rubber stamp something that somebody else has written. So, with that, having said,
I have one more thing. So,
Yes.
Barbara, when you said that you didn't have to do a meeting change, what about on Friday?
Friday, 4 o'clock.
I've already done that.
Okay, so that wasn't the one that you were mentioning that you don't
No,
have to
no.
do now?
No, the meeting is noticed for 5:30 tomorrow, and it will be noticed for 4 o'clock on Friday.
Okay, thank you.
All right, it is then the decision of the chair that we will continue this until 5:30 tomorrow, and if need be, also to 4 o'clock on Friday. And having said that, thank you very much for all your time, and while we are still on the record, I want to thank the parties to this for doing an excellent job of briefing and bearing with us during this seemingly endless discussion tonight that hopefully will lead to a decision that everybody can understand and can live with. Having said that, we are adjourned for the night.